Good morning, everybody. Happy Wednesday. Welcome to TCF Live. My name is Dan Soul. I will guide you through this 3-hour journey through Courtlandia. We will start our day in Michigan. This is Judge Middleton.
More as we go further. Here with us this morning is Jeanette Jackson from the Public Defender Office. She's here to make sure that we are following the proper protocol and that your interests are protected. And we'll see how we do. First case I'm going to call is Alyssa Oswald. Would you come forward, please? Good morning. Oh, come on. None of my arraignments are in here.
Oh, shoot, sorry. That's all right. Go ahead.
My sentences are all in here. My motion is in here, but none of the arraignments are in here. Ms. Oswald, give me a minute while I look up your circumstance here. We're not in any time crunch. I didn't notice that. Refresh it. There it goes. It was in there, it just hadn't been refreshed.
So, do you have a telephone?
I did, yeah.
Maybe just squeeze it in there. If you want, you can. That's your information, so the court can contact you. Oh.
Thank you. All right, we're off like the proverbial herd of turtles. The file number here is lost your case. I had it right in front of me. This is an old case, 252077 SM. Are you Alyssa June Oswald?
Yeah.
You got charged in a formal complaint that alleges way last June 23rd of 2025, that you assaulted Jeannie Bontrager,
I don't know
Chelsea
their-
Rice,
Who?
Chelsea Rice, and Christopher Bontrager. That's the allegation. Now that allegedly it happened in June. Let's see when they authorized the complaint. The complaint was signed by the prosecutor in September of 2025. Apparently they didn't get around to arresting you until recently. When did you get charged with this? Did they arrest you?
They just did it the other day. Well, not the other day, like the other week. They were like,
How'd you come to get arrested?
I was driving to my friend's house and a cop pulled me over, and I think he
They
knew I had a warrant.
found the old warrant.
Yeah, I think he knew I had a warrant, so he pulled me over.
Do you still live at Orange Street in Sturgis?
No, I live at Lafayette in
Oh, you still live
Sturgis.
in Sturgis. Apparently they got this warrant and then nobody ever worked very hard to serve it. Arrested almost a year later. warrant was entered in October and you got arrested May 16th. Well, these are just allegations at this point. The allegation is that you, on June 23rd, got into a dispute with Janie Bontrager, Chelsea Rice, and another Bontrager. And there are some witnesses that said you were punching these people. Anyway, assault and battery is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. You don't have much of a criminal record. You have an unpaid speeding ticket.
I do?
Mhm.
Oh, no.
I'll give you a copy of it. Once upon a time, they would suspend your driver's license. You owe $156 from a speeding ticket from 2021 that you
I didn't
never.
even know I had one. Because last speeding ticket I had, I came up here and paid it.
Well, this
So,
shows as unpaid. I'll let you check. In the old days, they used to suspend your driver's license.
oh, I wish they would
For an
have, so I would have
unpaid ticket.
known.
Anyway, this is 3 counts of assault and battery. I don't know much other than what I'm reading here. It's a year ago. My advice, and probably Ms. Jackson's advice, would be that you plead not guilty and we get an attorney to help you with this.
Okay.
Do you have an objection to that?
No, I have no.
Said attorney pretrial.
No.
I can't remember when that is. I remember doing it July 10th or June 30th. Let me look. Good thing we're not in a hurry because I'm sure not moving very fast. Let's see, June 26th.
I have till 10. No.
All right, we got. It'll be June 26th at 8:30. The first Friday in July is a holiday. Nobody will be here. Deputy Metz is going to take you out to the court office. We'll get a court-appointed attorney to represent you in this matter. I want you to call that attorney and make an appointment to discuss this matter with them prior to that 26th date. Here is the unpaid ticket that we show that you owe from 2021. We'd probably do a lot better job of collecting those if they still suspended people for not paying a ticket. But
Swear they would.
all right, you go with the officer and we'll get a lawyer and I'll see you on the morning of the 26th.
Wait, what day?
June 26th
What-
at 8:30.
Do you know what day that is?
It's
Is
a
it-
Friday.
Right, okay, back.
All right.
I'll give you a paper to remind you, okay, put it on the calendar.
She has priority issues, my friends. You're up in front of the judge for allegedly assaulting 3 people, and she's like, okay. Oh, and you've got an unpaid speeding ticket. What the hell? That's outrageous. And oh, can you tell me how calendars work? Anyways, good morning once again, everybody. TCF Live on a Wednesday. Barbara, 5 gifted memberships and a $10 super chat. Let's start this court party, she says. Dan is number 1. Thank you, Barbara. I appreciate your generosity. Let's get back to court.
Lots and lots of these. No insurance is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $500, not less than $200. Judge Patterson sits in a little booster seat in here, but I take it off. I probably could use it. He's got a pad that raises the chair up. I sit down so low, I feel like I'm a child at the adult table. as I indicated, that's punishable by not less than $200 and not more than $500.
Mhm.
Do you have insurance now?
No, I don't. I've been having trouble just trying to go get that stuff.
How about the plate? That's not valid yet either.
Not guilty.
All right. Do you plan to get insurance?
Yeah.
I would suggest maybe we adjourn this a couple weeks, and if you come back in with insurance and a
Right.
proper plate, the prosecutor could give you some consideration.
He's thinking he needs at least maybe 4 weeks to get this. He has to transfer from Indiana, so it makes it a little more cumbersome.
All right, I'll show you a plea not guilty.
Mm-hmm.
I'm gonna give you 4 weeks to come back with your license,
Insurance.
excuse me, with your insurance
Alrighty.
and your plate. Let's see if you owe any money. You owe from same thing. No proof of insurance in March and misdemeanor registration plate in March. What is the status of those? 261. All right, if you keep driving around with no insurance and no plate, you're gonna end up going to jail. It looks like you've got some from earlier this year. Let's see what I can figure out about those.
Your Honor.
Yes?
Speaking with him just now, I just learned some new information. I think maybe he needs an attorney to help guide him through this process this time.
Yes, let's back up. You got a ticket on
Mm-hmm.
February 28th for driving with no proof of insurance,
Mm-hmm.
which you probably did nothing about. They
Yeah.
also charge you with no plate, which you did nothing about.
I haven't had money back.
Yeah, so all you did is drove again and got the same charge, except they upped the charge. So as I told the first lady, in the old days, if you didn't pay your ticket,
Mm-hmm.
they would suspend your license. It's called FCJ, fail to comply with judgment.
Okay.
If you got a ticket and didn't answer it, they would suspend your license.
Okay.
That was called FAC, fail to answer citation. Well, you didn't do that. If it was up to me, I would still suspend people's license for not answering their ticket or not paying it, but
Right.
the legislature had other ideas. So you got the same charge in March. You don't yet have insurance, you don't yet have a plate, and you don't have the money. Does the car you got here in today have?
No, it's not. It's at home.
Sorry.
I haven't driven it since the last
All right,
time.
so that's a plus. All right, I'm gonna, same thing. I'm gonna know it also has when you get a ticket, you're not just supposed to ignore it,
Right.
which is what you did. But I guess when you do ignore it, nothing happens. So I don't know, it wasn't my idea. Show you plead not guilty, set attorney pretrial. Are you missing work right now?
Yeah, I just started a new job.
What time do you start work?
4 in the morning.
Oh, gee. We're gonna set this for June 26, 2026. 8:30. Couple pieces of advice. I would advise you to pay off or do, well, maybe not. We'll set all these things for the same time. Have money to pay off these tickets. Get proper insurance, get a proper plea, and stop driving around without insurance or a plea.
All right.
They can just run, they can tell by looking at your plate that it's not valid, but they can run your plate and it will show whether you have insurance or not. And this is his advice and rights. So see what you can do between now and June 26th. They're going to give you some paperwork with your lawyer's name and number on it. I want you to call the lawyer and make an appointment to discuss this with the attorney. And I'll help you with this when we have the pretrial on the 26th of June. All right, you're good to go, sir. We also have a couple of city
Alrighty, friends, once again, happy Wednesday, TCF Live. Good to have you here. If you're new to the channel, my name is Dan. Welcome. We have fun here. Let's go, we'll stay in Michigan, but let's go to Otsego County, where justice is best served in a converted pole barn. This is Judge Mertz.
We do have him video. The jail was able to get him. I know it's a little bit early. So we'll call People versus Luther Jones. This is file number 266961. Mr. Jones, are you able to hear me okay?
Yes, sir.
All right. If I could have counsel put your faces on the record.
Good morning, Your Honor. For the record, all the people. Thank you, Your Honor. Richard Trushkin on behalf of Mr. Jones.
Mr. Church, could you tell me the status of this file today, please?
Your Honor, I think ultimately we're going to be requesting one last adjournment. This is the situation as it is. I'm somewhat loath to do this, but I don't see another way to address it. I think in principle, we have an agreement in regards to this file. There's another file in district court that's set for a preliminary exam on Friday. I was cautiously optimistic that we were going to be able to resolve that. But frankly, after viewing the video of the incident in the other file, I don't think in good conscience I don't think I could advise him to tender a plea after viewing the video. We're set for a prelim on Friday. My hope is that once that prelim is over, either I'm right about this or I'm wrong, but I think it's going to give us clarity to be able to resolve this.
Okay. Mr. Rolla, do you have any objections to the adjournment in this file?
I don't, Judge, but I would also want to indicate for the record, as the courts also know, and as was discussed previously, Mr. Jones has matters of significant nature also waiting for him in another state, Texas. And in fact, our office received confirmation a short time ago that they will not be further pressing their matters until ours are done. So where it was previously that they wanted him right away, that immediacy no longer exists.
Okay. All right. Mr. Jones, have you talked to your attorney about this?
Yes, sir.
And is that how you would like to proceed as well?
Yes, sir.
Okay. All right. So we'll set this for a plea hearing. I the status conference in July. Forward at that time. So I'm assuming Mr. Trush, either that other case is going to have been dismissed, or there'll be some type of agreement that would involve that other case.
Yes, my expectation is one way, I mean, we're set for exam Friday. One way or another, something's gonna happen.
Okay. Sounds good. Thank you. Mr. Jones, do you have any question about how we're going to proceed with your case?
No, sir.
Okay, thank you. That's all for today, and the court's going to dismiss this time. Ma'am, can you tell me your name, please?
I think that's Miss Moses.
Ms. Moses. Ms. Moses, are you able to hear me?
Yes, Your Honor.
Okay. All right, we'll go on the record in People versus Ashley Moses. This is file number 256918. The record should reflect that Ms. Moses is appearing today by video from Department of Corrections. If I could have counsel put your appearances on in this case.
Record, Your Honor, I photograph people.
Thank you, Your Honor. Richard Trush appearing on behalf of Miss Moses.
Thank you. Mr. Trush, how do we want to proceed? I believe this is a final status conference in Ms. Moses' case today.
It is, Your Honor. We requested a trial and the court has accommodated us by giving us a trial date pretty quickly. With that in mind, there are some issues here. I am cautiously optimistic that we can work through those. So I have not been able to communicate with Ms. Moses since she's been an MDOC. I've tried to send JPEG emails to her. I have not got anything back from her. I've tried to schedule video visits. The facility will not allow me to do that. Without getting too deep into the weeds, when you go in and set it up, they have to add you to their visitor list in order to be able to schedule it. It indicates that I'm added to her visitors list, but it also indicates they won't allow me to set it up. So whenever I try to set it up, it just tells me don't effectively. We reached out to the court, I think probably about a week ago, to try to get a writ to have her transported here and maintained here until we can conduct the trial. Again, recognizing I don't want to lose the trial date that we have. One, because Ms. Moses is lodged, so effectively on dead time, but also trial dates are just hard to come by. With that in mind, at least to this point, MDOC has not done that. We originally tried to get a writ to have her transported. They told us basically no, we didn't give them enough time. We asked them to transport her for this hearing to just bring her in person. They told us no, because this hearing was scheduled via Zoom, so they wouldn't transport her. We prepared another writ yesterday, I think, to have her transported Friday. We couldn't get it signed within the 72-hour window. So I think at present we have a writ prepared for Monday to try to get her transported here. If we can get her here to the jail essentially next week, I think we can preserve that trial date and still be able to proceed forward. Additionally, the prosecutor has raised to me they may have an issue with their lab person on the current scheduled trial date. I would like to discuss with Ms. Moses. I anticipate that we would be willing to stipulate to the lab. I don't think our argument here is going to be about what the substance was. But again, I don't think I could do that without discussing it with her. And then the last issue to address with the court today, the prosecutor did file a 404B notice. I've been able to go through the information and talk to him about what it is he's seeking via 404B. And at least at this junction, I don't have an objection to it. We haven't filed one, and frankly, because I think it's appropriate under the statute.
Okay, so it sounds like we are going forward with the trial. There's not going to be a plea.
Well, again, that's my anticipation, but bearing in mind that I haven't been able to communicate with her since the last hearing.
Okay.
So what I would suggest is if she is transported here and we ultimately do come to some kind of agreement, I think we probably can find a time when everyone's scheduled to do it. Or at least take the trial date down if we know that's what's going to happen.
Okay. Mr. Rolla, do the people have any problems in terms of your witnesses?
The only issue is with Mallory Smith, even though our subpoenas were served over a month ago now. As the courts will aware, the crime lab individuals are requested in all sorts of locations. Oddly enough, in this particular case, for a matter in Montmorency County, our office is waiting a call back to Ms. Cunningham's office to find out whether Ms. Smith would be testifying on the first or second day of trial. We thought we had that problem worked out until then. We found out a second subpoena was served, a third subpoena served on Ms. Smith by the defense attorney in the Montmorency County case. And they are currently demanding her for the second day, which makes little sense for the prosecution. But in any case, I did bring it to Mr. Trush's attention. I don't believe their argument deals with what the lab report actually says. So the people would be willing to submit it to the court for signature a proposed in order to allow the lab report to be admitted without Ms. Smith's foundational testimony underlying it. Obviously, I understand Mr. Trush needs to speak to his client before he can sign such a proposal.
All right, so I guess here's how we'll proceed. Number one, I'm willing to extend the plea cutoff date due to the what I regard as a lack of cooperation from Department of Corrections, despite diligent efforts by counsel to contact his client. So I don't think it's fair to not allow a plea after today, given that lack of communication. So we'll leave the trial date on with the idea that we're going forward. I'm not going to schedule any additional dates in this case. To the extent that there is a plea agreement, I know that in the weeks between now and Ms. Moses' trial date, I'm going to be in a 2-week medical malpractice trial in Kalkaska, but I could certainly carve some time out during lunch or before or after those trial days to take a plea by video. So I will allow a late plea in this case. And I think this one is scheduled for the 28th.
I think the 29th.
The 29th.
Is that a Monday?
29th, 30th, yes.
I think it's Monday and Tuesday. Here. Yes,
It
it's
does appear to be
Monday.
Monday.
Monday, okay, so the plea would have to, well, I'm going to set a plea cutoff at by noon on Friday prior to, so that way, if there's going to be a plea, we know in enough time to call out the jury and so forth.
And again, in candor, Your Honor, I would anticipate by the end of next week, I would expect that I will have a firm answer one way or another. And if she hasn't been transported by then, I think I'm likely going to have to be submitting a stip to adjourn the trial while we figure something out. And I apologize, there's one last issue on this that I did want to raise.
Okay.
The prosecutor had brought to my attention 3 weeks ago, a month ago, somewhere in that time period, a potential conflict on the case. And that is one of the listed witnesses was also a former client of mine, that being Mr. Gallagher. Ms. Moses is aware of this. We've discussed this. When we last discussed it, I don't think she has any objection to me representing her, understanding that I did represent Mr. Gallagher previously. I've also discussed that with Mr. Gallagher as well. He also doesn't have any objection to that. I don't foresee it as a problem, but again, I just want to put that out there so that it's clear for everyone. And again, I don't view it based on what both of them have told me that their positions are contradictory here.
Okay. All right. We've got that preserved for the record then. Ms. Moses, do you have any questions about any of the things we've been discussing so far here today?
No, Your Honor.
Mr. Rolla, is there anything else we need to address on this file?
I don't believe so, yes, thank you, Mr. Trush.
No, thank you.
All right, Ms. Moses, if you don't have any other questions, we're going to disconnect at this time. Do you have any questions?
No, Your Honor.
Okay, thank you. That's all for today.
Alrighty, friends, I will keep an eye on Pole Barn Court, and we may go back there later, but let's go to Lake County, Ohio. Judge O'Donnell.
Novotny?
Your Honor, at this time, we'd like the court to consider continuing Mr. Burns on community control. From my understanding, Your Honor, since he's been on probation, he completed Met Talbot. He was doing an IOP with Catholic Charities. He was also living with his mother at the time, who he was caregiving for her. I believe she's diagnosed with cancer. I know there is something pending regarding that, and the court is aware as well that there's some cases pending, and he's in probation in other jurisdictions. From my understanding, Your Honor, he does have 100 days of total credit on this matter, but Your Honor, we're just asking for any type of leniency and to continue community control. Thank you.
Mr. Burns, what do you want to tell me?
Thank you, Your Honor. I take full responsibility for not reporting. As Ms.
Why didn't you report?
As Ms. Novotny alluded to, I am the sole caregiver for my mother, and she's been going through radiation, the tattooing, and all the follow aftercare, and I am the only one that was able to take her to her appointment. Unfortunately, we don't have a vehicle, so I had to be present for all the lifts there and back. As my mother's older, she doesn't know how to operate newer cell phones, so I had to be there with that.
So naturally, you called your probation officer and said, I can't be there because of everything you just told me.
Unfortunately, I used poor judgment.
Okay. Why not?
I was overwhelmed with everything that was going on. I also had issues going on with my daughter, who was in a mental hospital for a brief time, then was ruled as an unruly child by her mother. She also was found to be pregnant at only 14, so I had a lot going on there. I was briefly in Metro's burn unit with frostbite on my hands. That's originally why I missed my original report date, which I did let my probation officer know that was what happened. My hands were completely wrapped. I couldn't even do a belt or any type of buttons, so to get on a bus to go down there was a little bit harder, and I did let him know that was going on at the time.
Okay. You've been on probation a couple dozen times, right?
Yes, Your Honor.
Violated many of those times, right?
Yes, Your Honor.
Stayed on probation all of those times, right?
Yes, Your Honor.
Okay. So you figured you could do the same thing now?
Ultimately, this time was a little different. I had completed IOP, I was staying sober, and I was trying to be there for my mother. I knew I couldn't mess up because she would have nobody else. Like I said, I used poor judgment and didn't report.
Okay. Yeah, how do I know you weren't out there using again? I don't, because you didn't report.
If you look at my history, unfortunately, it is pretty poor. You'll notice I do tend to catch a lot of cases. If I was out there getting high, I would have undoubtedly been arrested and caught a charge.
What's pending in Parma now?
In Parma, those are charges from, I believe, 3 years ago. I believe it was failure to comply, drug paraphernalia, obstruction, and then one other. It's like two minor misdemeanors and two M1s.
What else is pending?
That should be it.
Mr. Berry, what's pending right
They
now?
gave me probation.
Hold on.
Sorry.
Your Honor, he's got 3 cases in Cuyahoga County that he's currently on probation. They have an active warrant on him for that. He's got a North Olmsted case that is pending, and then this Parma case is actually out of Old Brooklyn, and it's out of Parma Municipal Court, so they're wrapping that up as well.
And what's in North Olmsted?
I didn't catch that, I just know that he has a warrant out of North Olmsted.
Okay. So you don't like to show up? Otherwise, you wouldn't have these warrants out there, and you wouldn't be sitting here now.
It's typically when I'm intoxicated and I'm out there on a relapse.
You won't stop. You just won't stop doing the same thing. Okay, now you tell me you haven't used, but you still don't show up. Okay, so you use and you don't show up.
In the past, yes.
In the present, because you're
in the-
sitting here for not showing up.
Yeah, unfortunately.
Unfortunately.
I was trying to do my best to take care of my mother.
You cannot be on probation if you refuse to show up. It's impossible to complete probation if you don't show up.
I understand, Your Honor. And I was reporting before,
Usually a phone call takes care of that.
Yeah, I know.
Anything else you want to tell me?
I just hope for another chance to be able to take care of my mother is all.
Well, that's on you.
I know.
It's not on me, it's not on her, it's not on him, it's not on Cuyahoga County, it's on you.
I know, and I accept full responsibility for that.
Well, accepting, I don't know what that means in this context. I don't know what accepting responsibility means. Accepting responsibility really means complying with the privilege that you had to be put on probation. That's accepting responsibility, complying. And you've demonstrated throughout your life, the last 10 years, 8-10 years, you don't do that. And you won't do that. And you didn't do that. So you have abandoned the purposes of community control, so I'm going to find you are no longer amenable to community control. I'm going to sentence you to 6 months in prison with credit for 100 days and the costs. Anything else, Ms. Novotny?
No, Your Honor.
Mr. Barry?
No, Your Honor.
All rise.
CMS in the chat. What do we want? Time travel. When do we want it? Yesterday. Love it. Thank you so much. I've actually written it down as a merch idea. Good morning once again, everybody. It is TCF Live. Let's go back up to Michigan Judge Anzalone, where a defendant appears wearing a hard hat. Looks like he's planning ahead.
All right, I just admitted someone on a Samsung device with a hard hat on. So, sir, what's your name?
Zachary Rosenberg.
That's what I was looking for. All right, so let
Do you need me to
me.
take my hard hat off, Your Honor?
The next 10 days.
Are you allowed to take it off where you are?
Yes, at this point.
Yeah, I can take it off right now.
60 days.
Okay, then go ahead.
Matter, Your Honor.
All right, and Mr. Goldstein, are you ready on this one?
Yes, Your Honor.
Okay, this is in the matter of the file number 2023-21322FC, 2026-22525FH. Mr. Goldstein, you got another court going live?
Oh, sorry, Judge. I thought I'd muted that one, but I didn't. Sorry.
All right, okay. I have David Goldstein appearing on behalf of Mr. Rosenberg. Mr. Rosenberg and Mr. Goldstein have zoomed in separately. And I have Alexander Bayonetto appearing on behalf of the people. This is the date and time set for a probation violation pretrial as well as a final pretrial. So, Mr. Goldstein, how would you like to proceed today?
Well, Your Honor, according to my notes, we have a jury trial scheduled for July 15th. At this point, as far as I can tell, the matter was going to proceed. Obviously, Mr. Bayonetto and I will talk between now and then about resolution, but at this point, we are ready for trial.
We also have a letter dated June 2nd, stating that Mr. Rosenberg has continued to do his twice-a-week drug testing and has only been testing positive for marijuana, but he has a medical marijuana card. I also, though, have a note from Martina Aranda stating that we still don't have fingerprints on the newest file that is set for pretrial today. Let me see who the arresting agency is. It's City of Adrian. Mr. Rosenberg, I'm going to need you to reach out to the City of Adrian and set up a time to go get your fingerprints done. Okay. Oh,
Your Honor,
yes.
he went yesterday because he wanted to get them done by today. There's no order. There's no order. He needs an order.
I talked to Sergeant Keene.
I'm sorry, Zach, say that again.
I talked to Sergeant Keene yesterday, and she said that there was no order form for me, and that there was nothing that she could do.
Okay, so we will email to Sergeant Keene today a copy of the fingerprint order, and then you should be good to reach out to her again. Okay, Mr. Rosenberg?
Okay.
Okay, thank you. So we will continue this matter to trial. Has there been a plea offer made on the 2026 file, Mr. Bayonetto or Mr. Rosenberg? Or Mr.
Yes, Your Honor.
Goldstein?
Go ahead, Alex.
Plea to one count, drop the other. No habituals.
All right, so plea to 1 4-year and the other one will be dismissed. Okay. All right, very good. Okay, thank you, Mr. Goldstein and Mr. Bayonetto and Mr. Rosenberg, you're all set. Thank you.
Thank you.
Thank you.
When is the
Thank
trial?
you.
When is the trial scheduled, Judge?
July 15th.
Okay, thank you.
Thank you.
July 15th, sir.
All right, Mr. Goldstein, I believe that's all you have with me today.
That's it, Your Honor. Thank you.
All right. You
By
have
the
a
way, I
great
hope
day.
you,
Thank
I
you.
see you're feeling better.
Finally. Yeah, finally.
When I was talking to John Shea and told him that you had pneumonia, he was worried about you, so.
Well, that's what happens when you travel and you go from a cold, wet climate to a hot climate. So, yeah.
Good. I'm glad to hear you're better.
Thank you. Bye.
David Goldstein, now famous for breaking like HIPAA laws by disclosing why Judge Anzalone was sick. She never said, folks, at least on any stream that I've seen. She just acknowledged that she'd been sick for like a month, but he just outed her, I guess. Let's go to Florida. Wade Mercer.
Have a warrant notice we received from the Bay County Sheriff's Department. It says they have a warrant for you for violation of community control, and it has no bond on it. Mr. Henderson, what that means is you'll be held with no bond until you can get to Bay County. When you get to Bay County, you'll go to a first appearance judge, and that judge will talk about your case further. But right now, you have a no bond warrant. Bay County usually picks people up within a couple of working days to transport down there. Mr. Henderson, do you have any questions?
No, sir.
All right, sir. I wish you the best. David White. Mr. White, good morning. Mr. White, you're here because you've been accused of one count of grand theft and one count of burglary of an occupied structure. These are two third-degree felonies. Mr. White, there is probable cause in the complaint, and your criminal history, which I did review, it's pretty lengthy. I think it looks like you got out of prison January of this year, according to the Department of Corrections website. So I think you're entitled to a bond as far as I can tell. I'm going to listen to the attorneys and I'm going to set your bond. Mr. McDaniel, anything on behalf of Mr. White?
Your Honor, they were in court yesterday, and I think he was by Zoom, and Judge Garcia informed him about this and asked him to come turn himself in. He come straight over and turned himself in. He is on bond, just recently for something, a driving offense, and I don't think he's a flight risk based on what happened yesterday. We just asked the court to take that into consideration.
Okay, let me check and see, because this warrant was recent. I just signed a warrant on him last week. Actually, it was the first of this week. Supposedly occurred on May 15th. Mr. Mitchell?
I think the offense, in 26265 CF, which he was there for yesterday, according to the information, occurred of May 16th, so the day after. So
this does not revoke the bond?
This is not going to violate the bond, but given those circumstances and given that he's already out on bond, we're asking for a little higher bond.
It's the exact same posture as the other defendant we saw yesterday.
Yes.
He had another case pending, but that charge allegedly, he wasn't on bond when this one occurred.
Yes, that's correct.
The only difference is Mr. White may have a little bit worse criminal history. I don't know, the other guys wasn't too good either. All right, so Mr. White, what I'm gonna do is I'm gonna set you the same bond I set your co-defendant, which is $5,000 each count. That's $10,000 cash or surety, Mr. White. You have a condition, no contact with the alleged victim, sir. No contact with the victim's property. You'll get a chance to use the phone, Mr. White, in just a few minutes and try to post the bond. Mr. White, the jail's also going to give you a notice for your court date. It will be when?
I think the 7th.
July 7th, but because you've got another case going on, Mr. White, they may lump those together and get them on the same court date. So I'm telling you July 7th for now. It's possible it'll fall on a different date, depending on what you were told yesterday. Mr. White, do you have any questions?
No, sir.
Wish you the best, sir.
Yes, sir. He was set for arraignment yesterday, so they'll both be arraignment cases on the 7th.
Thank you. We have David Henderson, Davida, Brannon, and Stephen Johnson. David Henderson, Davida, Brannon, Stephen Johnson. All right, which one of you gentlemen is David Henderson? All right, got Mr. Henderson, we got Ms. Brannon in the morning, in the middle, Stephen Johnson on the right. So I'm seeing you at the same time because you're all accused of violation of probation or community control, and your first appearances are almost identical, with one exception, which I'll tell you about in just a second. Mr. Henderson, you have a no bond warrant. Ms. Brannon, you have a no bond warrant, all signed by the circuit judge. Mr. Johnson, yours has a bond on it. Based upon the type of violation, it was largely financial in nature. Judge Garcia has set you a bond of $1,842 cash. So the other two have no bond. You have an $1,842 cash bond. Mr. Johnson, I'm going to arraign you this morning, which means I want to get you a lawyer appointed to represent each of you if you want an attorney. Mr. Henderson, do you want an attorney appointed to represent you? You may be muted. I can't hear anything. I don't know if he's muted or. Would you like an attorney, sir? All right,
Yes,
and Ms.
sir.
Brannon, would you like to have an attorney appointed to represent you?
Yes, sir.
All right, and Mr. Johnson, same question?
Yes, sir.
All right, I'm going to appoint the Public Defender's Office of the 14th Circuit to represent each of you. Listen to Mr. McDaniel, and then I'll see if you have any questions in just a moment.
Your Honor, we're going to plea of not guilty, set these on the July 9th pretrial docket, and I advise them that attorney will come visit the ones that are in custody prior to that hearing. Ms. Johnson just needs to be there on the 9th.
July 9th, and for Mr. Johnson's benefit, if he's out of custody, what time of day? Is that a 1:30 docket or a different time, Mr. McDaniel? Do you know?
8:30.
8:30 either way?
Yes.
So, Mr. Johnson, if you do post bond, your notice will be for July 9th at 8:30. So what I would suggest, what I'm going to ask you to do is go ahead and give him that notice, Corporal, for July 9th at 8:30. If you're in jail, they're going to bring you up for that court date. If you post bond, you'll already have your court date notice. Mr. Henderson, do you have any questions?
No, sir.
All right, I wish you the best. Ms. Brannon, do you have any questions?
No, sir.
Wish you the best, ma'am. Mr. Johnson, any questions?
No, sir.
All right, wish you the best. Hope y'all have a good day. Mr. McDaniel, I think that's it for our first appearance list. We do have a couple of jail, just arraignments or pretrials?
I think they're both arraignments.
Both arraignment cases. I do see that we had Ms. Kelly appearing by Zoom for one of these cases. Good morning, Ms. Kelly. And Ms. Kelly, you have Nicholas Tindall, is that right?
Yes, Your Honor, I do. I was recently appointed to Mr. Tindall's misdemeanor case, and I believe I was also appointed to his felony yesterday. I have not had a chance to meet with Mr. Tindall. I will do so midday today. So if we'll just enter a plea of not guilty on his behalf for arraignment, and I would ask for the next court date so I can have a chance to meet with Mr. Tindall.
Thank you, Mr. Mitchell. Ms. Kelly, just for the record, it's case number 26-225 MM. Mr. Tindall is charged with one count of violation of injunction for protection. So the next public defender or regional conflict counsel court date will be when, Madam Clerk? July 8th. Mr. Mitchell, you okay with that?
Yes, Your Honor.
Ms. Kelly, you okay with July 8th?
Yes, Your Honor.
Mr. Tindall, I'm going to schedule your case for July 8th. As you heard Ms. Kelly say, she's just gotten appointed to the one case yesterday. This appointment was within the last week or so. So she's going to come see you at the jail. Mr. Tindall, do you have any questions?
No, sir.
All right, sir. We'll see you July 8th. Thank you, Ms. Kelly.
Okay. Well, yeah, I do have a question.
Okay, go ahead, Mr. Tindall.
I was scheduled yesterday to come back at June 16th, or we're.
You have
Okay,
two different
okay.
cases going. That doesn't change. So that's your
Okay.
felony date,
All right.
and now you've got a misdemeanor date. Okay? Have a good day.
And Mr. Tindall, I'll discuss both with you when I come see you.
Thank you, Ms. Kelly.
Thank you. Y'all have a good day.
Thank you. You too. The last case on the jail in custody date docket is State versus Alfred Jones, case 26221 MM. Mr. Jones, good morning. Mr. Jones, I'm appointing the public defender's officer to represent you in this case. Please listen to Mr. McDaniel. We'll see if you have any questions in just a moment.
Your Honor, I spoke to Mr. Jones. He's going to plea of no contest to the charges listed. Understanding he'll be sentenced to $60 fine, 36 days jail credit.
John.
Somebody covered the microphone there. We couldn't hear anything you said there for about 5 seconds. So can you start over, Mr. McDaniel?
Yes. Your Honor, I spoke to Mr. Jones. He's going to plead of no contest to the charges listed, 60 days in the county jail, $370 fine, 36 days jail credit, waive his right to a jury trial and call witnesses, and that'll resolve this case today.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Jones, did you hear that agreement?
Yes, sir.
Mr. Jones, do you have any questions about that agreement?
No, sir.
And sir, is that the plea that you would like to enter?
Yes, it is, sir.
Mr. Jones, I'm going to accept your plea of no contest to the charge of loitering and prowling in case 26-221 MM. Judge, you're guilty of that offense, sentence you to 60 days in the Jackson County Jail. Credit for 36 days you've already served, $370 court costs and fines. Mr. Jones, If you get the court costs and fines worked off through the trustee program, then that's great. If you don't, there'll be a civil judgment against you. Either way, there's no probation to follow. Mr. Jones, you finished this sentence. This is all put behind you. Mr. Jones, do you have any questions?
No, sir, thank you.
Yes, sir. Wish you the best, Mr. Jones. So I'm a little confused. So we have a first appearance case on my court calendar of Charles Ablett. Why would that be on there? Driving license suspended, revoked. It's disposed of.
Was pay by dates or something.
I wonder if that's what it is. That's what it is. So someone set a court date event for the pay by date. So, well, you can look at the disposition, you might recognize the handwriting. It's too neat to be mine. Yeah, so the due date right there, pay by, so that they created a court event. I don't know if it's, yeah. All right, so Mr. McDaniel, that's everything I have. Anything else for the public defender's office?
No, Your Honor.
Thank you, sir. Corporal, anything else from jail this morning?
Alrighty, friends, once again, good morning. My name is Dan. Welcome to TCF Live. Good to have you here. Creeping up towards the end of hour one. Let's go up to Michigan. We'll check in with a certain Judge Simpson. Undoubtedly, in celebration of America's upcoming 250th birthday, young Reagan is in attendance this morning.
Okay, Cedric Simpson was on. You may be seated. I apologize about my delay, folks. All right, Mr. Cook.
Morning, Your Honor. Raymond Cook for the people. Your Honor, the people believe any conflict in this honorable court in the office of the public defender. While the people do not believe that any such conflict exists, we make this waiver in the avoidance of all doubt.
Thank you, sir. Mr. Buckovich.
Assistant Public Defendant Buckovich. Likewise, Your Honor, public defender does not believe conflict does exist within his honorable court and the office of the public defender. However, one does advise we do waive it.
All right. Court for its part also does not believe there's conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the cases of the people versus Anthony Holston.
Morning, Your Honor. Raymond Cook for the people.
Conrad Silver on behalf of Pittsfield Township.
And Assistant Public Defendant Nicholas Buckovich on behalf of Mr. Holston in all matters.
And Mr. Holston, can you state your name, please, sir?
Anthony Holston.
Thank you. What are we doing?
There are three forms, Your Honor.
Are there? Got it. I have.
You one for all the township cases as well as one for the state cases.
I have two files marked for pleas. Is that right?
Yes, that's correct.
Okay. In the case ending in 0070, the court's understanding that he's going to plead to the charge of trespass. 30-day offense. Upon his successful plea to that charge. Don't you guys set this up? Okay.
The other four township cases would be dismissed, Your Honor.
Right. I would have the case ending in 0020, 0021, 0069, and 0067 would be dismissed.
That's correct.
Yes, Your Honor.
So those four would be dismissals upon his plea to that charge. The other matter, case ending in 0800, going to plead to the charge of retail fraud, second degree, the 1-year offense. Upon his successful plea to that charge, counts 2 and 3. In this case, as well as the case ending in 798 would be dismissed. Defendant in that case is agreeing to pay restitution on all counts, including dismissed counts, and the prosecutor will recommend fines and cost and restitution. Now that I've sorted all those files out, that's the court's full understanding of the agreement.
As it relates to the state's cases, that's correct, Your Honor.
As for the township cases, that's correct.
As to all cases, that's correct, Your Honor.
All right, very good. All right. Sir, can you please raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again, please.
Anthony Holston.
All right, starting in the case, ending in the township case. Sir, it is this court's understanding that you're going to plead to 2 misdemeanor charges, but in that case, you're going to be pleading to the charge of trespassing. That's a misdemeanor punishable by up to 30 days incarceration, a $100 fine plus court costs. You understand that, sir?
Yes.
In the other case, you're going to plead to the charge of retail fraud 2nd degree. That is also a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
To the charge of trespassing, how do you plead?
Guilty.
To the charge of retail fraud 2nd degree, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial in either of those matters.
Yes.
You have executed on your behalf after going through it an advice of rights form, is that correct?
Yes.
Do you have any questions regarding any of those rights?
No.
You understand you're giving up all of those rights, including the rights under paragraph 5, which are your trial rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
All right. You're not on probation and you're not on parole. Is that correct, sir?
No, sir.
Oh, well, we did that wrong. You're not on either one of those. That is correct.
Right. I'm in prison right now, sir.
You're incarcerated. That's what, yeah, right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you in any way?
No, they haven't.
You're doing this voluntarily and of your own free will.
Yes.
And also because you believe that you're guilty of these offenses?
Yes.
On the date of starting with the trespassing case, December 27, 2024, location of 3145 Ann Arbor Saline Road, Pittsfield Township, Washtenaw County, State of Michigan. Were you on the property of Meyer?
Yes.
Had you previously been told that you were not welcome on that property and that you could not enter that property?
I don't really remember, Your Honor, but if they say I did, I'm sure they did.
Oh, well, we're gonna have a. So you don't recall being told not to go on that property?
I mean, from where? From the hospital or what?
No, this was at the Meyer on Ann Arbor Saline Road. Well, when was the date? You know what? Let me do it this way, sir. Because I think one of these cases leads, no, it doesn't. So at the 3145, you don't recall whether or not they told you not to go onto the property. And if you don't recall, that's okay, sir.
I mean, yeah, I vaguely remember. I mean, yeah.
Okay, let's try this. Let me go to the other case, okay?
All
And
right.
then can you, if it's acceptable, can somebody send a police report on that one, on the trespass and I'll try to get it done, but get it done as a no contest.
I will try to send both.
Try to send it over. Okay.
Nobody over right now, Your Honor.
So let's do this, sir. On December 22nd, 2024, location of 3825 Carpenter Road in Pittsfield Township, that also being a Meyer. Did you go into the store on that occasion, sir?
Yes,
All right. Did you try to take items from the store without paying for them?
yes,
All right. And the store was open to the public at the time that you went there?
yes,
You didn't have anybody's permission to take any of that property, did you?
no,
And the property that you took was property that Meyer had offered for sale?
yes,
And had you previously been convicted of retail fraud in the second degree back in the 62A district court? I don't have a date.
I believe January 26th of 2018 or January 9th, 2018, both were.
2018 or 19?
Both,
Yes.
both 20, it's either January 26th or January 29th of that year.
Okay. Do you recall being convicted previously of retail fraud second degree, sir?
yes.
All right. So I have that one.
And I'm sending the police report right now, Your Honor.
All right.
Sorry about that.
Sir, we're trying to so that we can resolve the trespassing case. We're having the police report sent over. My understanding is that you would be changing your plea to a no contest plea?
I mean, yeah, I mean, if that's acceptable, I mean, I can't say to you that somebody told me on that particular time because what's going on with that is that I'm not from your county, so I got stranded there for 2 weeks and that's what all this stuff is. So I don't know if that was the first time that I went there. You know what I mean? Like, I don't know if that was the first time that I went there and committed that retail fraud that somebody told me not to be there. I don't know what date that was. So I can't really honestly say to you that they told me what that was because I'll be honest with you. I went in there a few times.
Okay, I got you. And that actually, Mr. Holston, that all makes sense. I get it. So if you change your plea to a no contest plea, that would mean that you're not further wanting or desirous to contest this charge of trespassing. You understand that, sir?
Yeah, I'm not contesting it. Yeah, I'm sure. I'm sure if they said that I did that they told me, I don't think that they're particularly lying. I just don't recall them telling me that I wasn't supposed to be at that particular time.
Sir, I understand all of that. I'm just trying to get this done. So if you're going to plead no contest to that charge, you understand that all the rights that I indicated to you before would apply to a no contest plea as well as a guilty plea.
Yes, I do.
All right. And you understand that upon pleading no contest, that the court would treat you the same for purposes of sentencing as though you had pled guilty. You understand that, sir?
Of course.
All right. And so the court has been provided Pittsfield Township Department of Public Safety report for their case 24-21532. Any objection to the court reviewing that report?
No, Your Honor.
All right. And Mr. Holston, just as a formality, to the charge of trespassing, how are you pleading now?
No contest.
Thank you, sir. Got it. and the court is accepting it based upon a review of that report, the court does find that there's a sufficient factual basis. I would indicate that based upon the court's review of the police report that the defendant doesn't remember. There's also an indication that the time of this offense that he was highly intoxicated to the point that he was taken to the hospital at that time. So I do have to, until the court does find there's a sufficient factual basis. So I do have to advise you, if we do, between the time of my acceptance of your pleas and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you will not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, sir, I do.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Statement.
No, Your Honor.
All right. And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
All right. In the case ending in 800, which is the state case, the court will accept the defendant's plea to count 1. Counts 2 and 3 in that file are dismissed, as well as the case ending in 798 is dismissed. In the other matter, court having found a sufficient factual basis, the court will accept the defendant's no contest plea to the charge of trespassing. And cases ending in 0020, 0021, 0069, 0067 are dismissed. Are there going to be issues of restitution on these?
Very
Not-
minimal.
There's no
Amounts.
restitution in the township cases.
On the state case, it's going to be a very minimal amount. I believe that half a bottle of Fireball drank by the defendant as part of that offense, which obviously they weren't able to recover, and I don't know the value of that. So it's a big.
A half a bottle of Fireball?
I was gonna ask.
Well, how much does that cost, Bukovich?
Yes, I hear you.
I mean, okay, that was wrong. I just thought I'd ask you. Maybe you knew.
I don't drink Fireball.
Yeah, okay, fine.
Courts inclined to leave restitution open for 30 days.
Yeah, but why don't we do that?
Yeah.
All right.
I was in custody for immediate sentencing. My client's been in custody since July 2025 with an estimated release date of November 2027. And I know Mr. Sill has indicated he has no objections to immediate sentencing in the city.
That's correct.
All
In the
right.
township matters, I have no objection to immediate sentencing.
Mr. Holston, anything you want to say before I impose sentence?
No, sir. I actually went to rehab after these incidences, and I had a warrant come up, and actually that's why I'm here right now. So I'm actually trying to get. I've completed both my classes that were required for my parole stipulations. I completed ASAT here in the prison. I'm just trying to get. I'm trying to get my life back in order, and alcohol has been my number one legal problem, source of my legal problems. So I'm really trying to get that squared away and understand why that it is that I keep going back and doing the things that I don't really want to do, and doing these, idiotic things like going in and stealing bottles of Fireball, that I don't do sober. So I just want to say that I'm sorry, you know what I mean? There's really no more I can say. I got a problem and I need to deal with it, and I need to seek help for it. So that's what I'm doing right now.
All right. You'll get there. On the township case, I'll impose the state minimums of $125, 30 days incarceration, credit 30 days served on that case. On the state case, I will sentence the defendant to fines and cost of $125, which would be the state minimums, and 365 days credit, 365 days served. All right. Then you're all set, sir.
Okay, thank you.
Okay. Thank you. Okay.
Alrighty, friends, we're going to move along to Judge DeSanto's court as we enter hour 2 here of TCF Live. But before we do, I want to point something out a minute. So this is just a paused feed from Judge Stevens' court. They haven't started yet, so I'm not going to go there. But you'll notice that the camera is tilted, pointing out to the table there. And that's called a Dutch angle. So I kind of was looking at that. I was like, oh, they must be playing with new production value there, just kind of kidding to myself. But then I questioned, because sometimes you have these mild brain farts. And I'm like, is that really a Dutch angle? Do I have that wrong? I'm pretty sure it's a Dutch angle. Let me double check. So I went to Google. And here's an interesting little Easter egg. If you Google Dutch angle, YouTube actually tilts the page on a Dutch angle. That's a super cool Easter egg. It's very hard to give Google and YouTube and all of that credit for a whole lot these days, because they seem to mess with a lot of things, but that's actually kind of cute. It's a nice little Easter egg, so I thought I would point it out. They actually demonstrate for you in real time what a Dutch angle is if you Google Dutch angle. So anyways, just thought I would share. Okie dokie, sharing time done. Let's go to Judge DeSanto.
All right, thank you. And then there's also show causes on the civil infractions that your client has, which is 23W78285 A, B, and C. And then we have 251719 CI. So let me just see if I have all these. I have 27825. I don't think we have the 25. Oh, unless
1790 or 19. That's gold balls.
Okay, well, let's pull that because he has Mr. Westmoreland on the 26 cases. Can we grab that from Mr. Goldpaw? If he has it. Okay, thank you. And so then, Mr. Westmoreland, I know you didn't have a chance to speak to Mr. Sletta about this one, but this is a show cause with $155 balance. So,
We did speak about all, so
Oh,
I
okay.
have them all on the topic sheet.
okay, very good. Okay. Okay, so also case number 251719 CI and Counsel, I'm sorry, your appearance again for the record, please.
Attorney Corey Westmoreland appearing on behalf of Mr. Slata.
All right, and sir, your name again for the record, please.
Johnny Slata.
Okay. All right, and so today is the date scheduled for the arraignment pretrial on the 26th case and show causes on the other matters. And so as to the arraignment counsel on the 26th case.
Yes, Your Honor, at this time we have formal reading my class.
All right, the court will read the formal reading, enter a plea of not guilty for purposes of the arraignment, and then as to the retrial.
Yes, Your Honor, at this time the civil attorney is offered to the original driving while license suspended to one count of allowing a distracted drive. And then the original no insurance misdemeanor to a civil infraction, no proof of insurance, and dismiss the distracted driving ticket.
All right, sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, and you heard the plea that was placed on the record, correct, sir?
Yes, Your Honor.
As to the amended charge of allowing a licensed driver to drive, how do you plead?
Guilty.
And you've gone over, and as to the no proof of insurance, the amended charge of no proof of insurance, how do you plead? Responsible or not responsible?
Responsibly.
You've gone over your advice of rights with your attorney, correct? And you understand all of those rights.
Yes, I do, Your Honor.
You also understand, sir, that by entering into this plea, you'll be waiving some of those rights.
Yes, ma'am.
You also have gone over the possible penalty as a result of your plea, whether in this court, any other court or administrative agency with your attorney, correct?
Yes, Your Honor.
And knowing all of that, do you want to continue with your plea?
Yes, I do.
Has anybody promised you anything, threatened you, or coerced you in anything to enter into a plea?
No, ma'am.
Okay, and so then counsel, if you can please voir dire your client.
Mr.
I'm sorry, any immigration issues? Okay. Is that a no?
No, ma'am.
Okay, and so counsel?
Mr. Swetta, were you operating a motor vehicle in the city of Wyandotte on April 2nd of this year?
Yes, I was.
On that date and time when you pulled over because you did not have insurance on that vehicle?
Yes,
And when you were pulled over, was your license suspended?
it was.
Satisfied, Your Honor?
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charges for the plea agreement. And counsel, you asked me for immediate sentencing?
That's correct, Judge. I would like you to know that Mr. Swetta is resolving all of his tickets and acknowledges that he does owe the money on the other tickets for the show causes that are up today as well. He is prepared to, he already checked them with the counter. They told him he owed $479 on those. He's prepared to pay that off. He understands he's not to operate a motor vehicle until he does restore his driving privileges. He's not going to put himself in this position again.
All right. Sir, how'd you get here today?
I walked through just a few blocks there.
From Horger Avenue?
No, ma'am. I told him I lived on 2nd Street, 776 2nd Street.
Okay, and so, do you have proof of changing your address, sir?
Yes, ma'am.
I'm sorry?
Yes, I do.
So is that what your license says?
No, my license has Harvard still, but I don't really have it actually.
You know what?
I don't have my license actually, but
I'm sorry. I should have said your state ID.
yeah, my ID doesn't say that, but I informed the officers that night.
Okay, I understand that, sir, but if you've informed the officers is one thing, but showing proof that that's where you're at is something different. Because surprise, surprise, people were told many things, officers were told many things are not accurate. So you have all right, and so, sir, where'd you work?
I'm not working actually. Well, I'm doing tree work, but not steady. Just working with a friend, getting jobs on my own.
Okay, and so why are you not, how long has it been since you've worked full-time, sir?
Since probably the fall.
Why is that?
I lost my license. And I was doing the tree work with DTE contractors. And I supposed to have my license. I told them I'd be getting it back. I got another 215.
Well, then stop driving.
Yeah, I mean,
Aren't you getting tired of all this?
yeah, I don't even have to do it, so.
And having to give your money to the courts because you're not getting it situated? Okay. Are you on probation or parole anywhere, sir?
No, me.
What happened with the matter that you had here in 23? Did that get resolved?
Yes.
All right. So the court's going to order a $100 fine, $200 cost, crime victim assessment fee of $75, justice system assessment fee of $50 on the on the allowing a licensed driver. So that's a total of $425.
I believe Mr. Sweda posted a $300 bond.
He did. And then there's also the no proof of insurance of $175. So that total, sir, is $600 is the total. So we can apply your bond, and then you have the money to pay the balance of your tickets as well?
Not.
The show causes.
Yes, I do.
Okay, so we apply your bond to your 26 case, and then you have a balance of $300. You need a payment plan for that?
Yes, if I could spread it out a little bit.
Okay. And, so on your $300 balance, sir, how much can you pay per month, and what date of the month works best?
$100 a month would work out for me.
Okay,
Maybe the 15th.
are you wanting to begin at June 15th,
Maybe I'll go towards the end of the month, that I can start.
June 30th?
Yes, please.
All right. So there's that. And then on the show causes, what I'm going to do, sir, is I'm going to indicate that you're paying full today. Okay, so on the 25 case, that's $155. And then there's $150 on the 23W78285A. And $114 on count C. And $180. So let me just confirm what the total is. Because council, I believe we said it was $400 and something, right?
$479.
Okay, so let me just make sure that all these total that, and we're all on the same page. Okay, I'm showing $599. So, count on the 23 case, count C is $114. On count A on the 23 case is $150. Count B on the 23 case is $180. Yes? Okay, I'm looking at the, show cause from December 25th?
Yeah, it looks like we're in February of this year, so that's why they're lower.
Got it. Okay. All right. I just want to make sure we're all on the same page, and now we are. Okay. So, all right, sir. So just stop at the window, make those payments on the show cause matters, and then you can begin your monthly payment.
June 30th.
Yes.
Thank you, Judge.
All right. Good luck to you, sir. You can even get information about paying online if you'd like. Okay.
Alrighty, friends, let's move along. We will go down to Texas. Judge Stevens, where apparently they have abandoned their Dutch angle idea, unfortunately.
Call cause number 26 CR 35, the state of Texas. And Mr. Franklin, could you please repeat your client's name for us?
Judge, I have attempted multiple ways times, and he's told me I've never.
It's Lakshnana. Lakshnana.
No.
Ayalasom Mayajula.
Yes.
Very good, Judge. Good?
Yeah, that's good. He
Shukriya.
goes by Avi,
He's
Your Honor.
Indian or Pakistani?
Indian.
Okay, okay. Kia Ale.
Thanks.
Shukriya. Okay. Let's, what are we going to do with this gentleman today?
Your Honor, we've just confirmed this week There was some discovery we were looking for. We confirmed this week that it does not exist because there was a multi-agency task force, is my understanding, involved in this.
I'll bet.
And so we need about a month to finish out what we're working on our end to get over to the DA to finalize our negotiations.
All right. This was filed back in the middle of January. And, sir, do you understand this is a state jail felony, which carries with it up to 2 years in the state jail? And it's a felony offense, even though it's the lowest form of a felony, a state jail felony, but a felony nonetheless. So it is very important that you work with your attorney on seeing what can be done to keep you from having a conviction. A conviction follows you, if convicted for a felony, it follows you the rest of your life. So this, if you haven't been in criminal trouble before, this very well could be fixable. But follow his advice. And if you have any questions or you need clarification, Mr. Franklin's a smart guy and he knows how to take care of his clients. All right, I'm going to give you, it's 3 or 4 weeks. What do you want?
We need probably 4 years.
4? Okay, try to get it moved on that day,
Yeah,
maybe,
Judge.
one way or the other?
Yes, Your Honor.
All right, please get a reset and thank you, sir. Good to you.
Thank you, Jim.
And then I have Tavian Thomas. Tavian Thomas, 25 CR 1774.
I'll sign there.
And
I'll have him sign that.
this is an initial appearance. I don't see an attorney. There is no answer in the courtroom. I asked the bailiff to call into the hall for Tavian Thomas.
If he's being, I say I don't.
I'll email you something.
Hey, Ellie,
Uh-huh.
is Mr. Thomas, is he in our custody?
No. I spoke with the bonding company last week when he no-showed and they assured, I told
Yeah, I
them.
thought he was in, he was in
I
there
also asked for a
last
copy of the
week.
bond, which they have not responded in any way, shape or form. But I was able to track it down to the sheriff's office, so we can do a forfeiture.
Somebody's coming in. Who are you? Who are you? You just can't walk. Who are you? Okay, you need to come up here. You're the man of the hour. Are you still at 207? Your address? Okay, I thought you would maybe move. We need to get an update on that. What is your new address? Is it still in China?
No, sir.
All right, where do you live?
1855 Island Street, OLLIE, 115.
And the zip is what? 06?
I think it should be 05.
Is it?
I think so.
77705. Okay. All right, you ever been in trouble before? Criminally?
No, sir.
You're thinking about it. No, you're certain about it.
Yes, sir.
All right, well, this is serious. You're charged with aggravated assault causing serious bodily injury to another person. Stand by. All right. Is this the case where we had, because it's the barbershop, is it the same
Done the other
incident?
thing already.
We've already dealt with another guy.
Yes,
There were 2 people, 2 of y'all, right? Involved in this?
Yes, sir.
All right. Yeah, well, we dealt with the other one already, and I didn't find that amusing. What happened here? Plus, it's on video. Okay. According to the probable cause affidavit, the victim was on his phone waiting for his brother to finish getting his haircut. You and another person entered the barbershop, began punching him with your face, with your fist in his face and head. And this was all captured on a video. And The victim ended up with a fractured jaw, which takes forever to fix. So, because that's a serious bodily injury, you're charged with a second-degree felony. If convicted, you face no less than 2 years in prison, up to 20 years in prison. Plus, if you're sentenced to prison, parole is not you're not eligible for parole until you serve at least 50% of your sentence. It's serious. It's probably next to the most serious types of crime, the first-degree felonies, which carry up to life imprisonment. But if you get a felony conviction, the felony conviction follows you around for how long? Forever, the rest of your life. Good luck getting a job worthy. Good luck on having doors of opportunity open. Good luck. So this needs to be fixed. Do you have a lawyer?
Yes, sir.
Who is it?
Kevin Lang.
I have no rec letter.
We have nothing from Kevin Lane. When did you hire him?
I just began in contact with him about 2 days ago.
Okay. There's nothing here that shows he's been hired to represent you.
We're in the process and I don't have. all the
Well, get
paperwork.
it, you need to get this done because I'm just gonna set this 1 week to get him in the game. 1 week to get him in the game. Well, I'm gonna reset it for 1 week. But this needs to move along. This occurred back in October of last year. So we're already 9 months into this and we move forward on getting cases moved in this court. So you got 1 week, get him or somebody. If you don't have somebody, you gotta come back anyway next week and explain to this court, what are you doing about getting a lawyer? All right.
Yes, sir.
All right, get a resetting and try to handle this responsibly because this is a very disturbing set of facts. All right, get a resetting.
I got
On that later.
it's the wrong copy. I need to send me a good.
Okay, let's get ready for this murder trial.
All right, I guess they're going to get ready for a murder trial. Let's go to Lake County. Check back in with Judge O'Donnell, new contestant there.
Thank you, Your Honor. Before you today on State versus Justin Ruth, file 26 CR 159. We're here today for sentencing. The state of Ohio has had the opportunity to review the pre-sentence report and is prepared to go forward. And I would remind the court that we have an agreed 2-year prison sentence as part of the plea agreement. Other than that, nothing. Thank you.
Ms. Tomazik?
Yes, thank you, Your Honor. I did have an opportunity to review the pre-sentence report. We are prepared to proceed to sentencing if the court is prepared to proceed. So, Your Honor, we do have an agreed 2-year recommendation for prison for Mr. Ruth. Mr. Ruth prior has done treatment. He did treatment at Wellbrook Recovery. He indicated he was sober for a year. He indicated that once these charges came to, he did become stressed. He did relapse a couple of times, so that is the reason for testing positive for the methamphetamine. Your Honor, he does have a plan in place for himself. He does eventually want to remain sober, get into treatment, and do whatever he can to make sure he stays on the right path. With regard to the controlled buys, Mr. Ruth indicated that he was buying the drugs and selling them to feed his own addiction. He indicated he would purchase extra drugs, sell the remainder and keep some for himself just to keep his addiction going. Your Honor, he does have a good support system. He is married. He does have children. His one child is 7 years old and does have special needs. He does try to be there for him as much as he can. So we just ask the court for any leniency today. Thank you.
Ruth, what do you want to tell me before I sentence you?
Would just like to say that I think that I would benefit more from treatment than prison. I don't think I should not have consequences, but
Treatment for what?
for addiction, sir.
Well, you told Miss Warren that the last time you used meth was in March of 25. And
That
you
was
tested
less-
positive in April of 16, so how is that possible?
When we were talking about active addiction, that was a year ago.
What does
I did-
active addiction mean?
The active addiction is when I was using regularly. I did relapse recently due to some stress, but I was able to put it back down. And
You tested positive. When you were referred for a PSR on April 22nd. And when that was addressed with Miss Warren, you indicated you don't know how that could be possible because you hadn't used since March of 2025. Why did you tell her that? Did you use, or do you not know how you tested positive?
I had used, Your Honor.
Then why did you tell her you didn't? That you had no idea how the positive test would have happened because you weren't using?
Because honestly, I thought I had quit.
What do you mean you
Well,
thought
I had quit long enough that I should have had a clean test.
So you lied to her? When you told her you hadn't used since March of 2025, and you tested positive on April 22nd of 26, and you told her you had no idea how that happened because you hadn't used for some 13 months, you lied to her. Right?
Yes.
I don't, you got some equivocation on that?
I wasn't actively using.
I don't know what
but
that
I
means.
had
If you
used,
yes.
yes.
Then you're active. Then
But
you're
I had
actively
used
using.
and thought I would have been
Okay,
clean.
why
by
are you
then.
trying to split hairs like this?
I was just being
See,
honest, sir.
now let's get to the next part of this thing. In your written version, when you went over for your referral, you said you were asked to get drugs from an individual you knew, and you wanted enough for yourself. When you talked to her, when she interviewed you when you came back, you indicated that the drugs, a large amount of drugs found in your bedroom where you stayed at this house, were not yours. But you decided you did things illegal in the past. You had been on drugs, but the drugs weren't yours.
What I meant by
So
that-
if the drugs weren't yours, it resulted in the felony 2 charge. Why did you plead guilty to this case?
Because I had drugs, and I was holding myself accountable for the drugs that I
Okay, so
had
you
in there.
didn't, these drugs weren't yours.
Those particular ones at that time,
In your bedroom weren't yours?
at that particular time, no.
Okay, whose were they?
There were 3 other active users in the house.
Active mean using.
Yes, sir.
Stop with the active and inactive. What's an inactive user? There's no such thing.
Correct.
Okay. So you pled guilty to an F3, which there's a presumption for prison. You know that, right? Because we talked about that.
Yes, sir.
Okay. But the drugs weren't yours.
Correct, at that time. But I had some,
At that
so-
time. That's what I'm talking about. The drugs found.
Mhm.
They could only have been found at that time. Those weren't yours. So how am I supposed to sentence somebody for a crime that they say they committed that they actually didn't commit? How am I supposed to do that?
Because I had committed that crime.
But you're not charged with in the past committing that crime. You're charged with, in this situation, committing that crime. Well, of course, the real answer is you're lying to me, okay? Because you lied to her. You're lying all over the place. Okay, so that's the real answer. Those drugs were yours, okay? You were living at the house at that time, right?
I wasn't staying at the.
What?
I was not staying at the house at that time.
You were staying versus living. We're gonna parse this definition now too. Where were you staying?
Most of the time I was staying at my wife's house.
Okay. And didn't you say somewhere along the line that you were in treatment at that time, so you weren't staying, living, whatever at that house?
I was preparing to go to treatment, and then.
Well, didn't you
I
say you
finally
were
got
in
like a
treatment?
week later.
Didn't you say you were in treatment at the time? As opposed to preparing to go into treatment at the time?
I got into treatment maybe a week later.
Right.
Is when I finally got in.
But did you tell Ms. Warren that you were in treatment at the time?
I told her that I completed treatment shortly after.
Whew. So you started this by saying you want me to put you on probation, right? Is that right?
At some kind of treatment, I think I would benefit from, yes.
Okay.
Further treatment.
Well, I thought you already had treatment.
I had some.
Okay. I mean, at best, this was kind of a half-assed treatment, wasn't it? Wasn't some of this on the computer?
I did a residential, and then was doing some online meetings and stuff. And
What do you do on an online meeting?
it's basically the same as in person. It's just over.
Well, it's nothing like in person. Okay.
The format is.
The format. Well, it's a complete waste of time. So the treatment you're talking about that you completed was Wellbrook Recovery?
Yes, sir.
And that was, you went in there on March 23rd, right?
That sounds about right, yes.
That's what the records show. And the offense here was committed March 18th. So when you said you were in treatment and you weren't at the house and it wasn't yours, that's not true. And it says here, are these records we have, or are these Mr. Ruth saying this?
They're records from the actual facility, Your Honor.
Okay, so May 6th is completed. And then you reported, which means this is you talking, that you would attend alumni sessions. What's an alumni session?
Alumni sessions are people that have graduated, from that program, become alumni, and twice a week they would have AA meetings, NA meetings.
And so you went twice a week
Yes, sir.
until this happened?
I probably stopped going to them, 3-4 months maybe before this event happened.
Well, this event happened before. So when did you?
Or before I got charged with that's what I meant, I'm sorry.
Okay. All right. Well, when did you, I'll ask this question based on what you're telling me today. When did you get involved again with the meth after you had stopped using after Wellbrook recovery?
When I got arrested for this and everything was going on, I got pretty stressed out. and
When did you get arrested for this?
Your Honor, I believe it was beginning of March of 2026.
And so by your story that you're telling today, you had been not using drugs for a year. You get arrested and you start using drugs again. Is that right?
That's correct.
Okay. And where did you get the drugs when you started using again?
I couldn't tell you the gentleman's name. I found him online.
How did you find them online?
It's,
What website did you go to say, where do I find a meth dealer in my area? Where?
it was an app called Grinder.
Grinder?
Mm-hmm.
Isn't that some kind of sex app or something?
It is, but I found that it's also full of people who,
So where did you find these drugs then, on the Grinder app?
someone that was advertising that he had drugs.
Who was advertising that?
The gentleman that I found online on that app.
I know, who?
I couldn't tell you his name. I've never seen him before or after.
So where'd you meet him?
At the Headlands Beach.
And how did you know who it was? How did you find this person?
He said I'd be in a red car, and I told him I was in a black car, and he came and gave me the drugs, and I gave him the money, and
Okay, so you only used once then?
twice.
Twice?
It was the same batch of drugs, but I used, yeah,
Okay, so you only bought drugs once?
correct.
Okay, what quantity did you buy?
A gram.
A gram. When you were using the year previous, for whatever period of time that was, how much were you using a day?
Probably 2 to 3 grams a day.
Okay, so you bought a gram from somebody that you met on some app that you connected with somewhere, bought a gram. How much was a gram?
$20, sir.
Okay, and so you used some of it, right?
Mm-hmm.
When did you use the rest of it?
I want to say it was April, somewhere around the
So
12th.
you saved some of that gram for a month.
I had thought I'd thrown it out and then found it again
Where'd you find it?
in my room near the trash can.
Okay. Boy, oh boy. That would be unusual that a meth addict would buy a gram of meth, not use all of it,
I thought I had,
and,
to be honest.
and then threw the rest away.
I thought I had used all of it and thrown the bag away. And then when I found the bag, it still had some in it, and I used again.
Okay. Other than that, you didn't use it all between March and April when you got arrested.
Correct.
Okay. Don't believe that. I don't believe that. So far, you've told me nothing that I can reliably believe. Who's Stephen Six?
That would be my roommate, the owner of the house that I was staying in.
How did you meet Stephen Six?
Honestly, I don't remember. He was a neighbor. I lived, prior to being at that house, I lived pretty close.
On what street?
I lived one street over on Glen Lodge.
And so, how did you meet Six? Through drugs?
Probably, Your Honor.
Well, so your story is that on these drug sales, or Six's story on these drug sales, is that he was acting on your behalf on the third sale. Is that true?
I don't, I mean, he had his drugs, and that's where I got him most of the time. He supplied a
Well,
lot of them.
the CI is the one that got you involved in this, right?
Yes.
Somebody you knew, right?
That I met through 6, yes.
Okay. And on the third controlled buy on March 10th of 2025, the CI set up another buy with you, right?
Probably.
Come on.
I mean, I can't.
I mean, I
recall
never saw
exactly.
anybody, you're like Bill Clinton out there, hedging every word, okay? So, you agreed to sell this CI some drugs on March 10th, and you weren't at the residence, right?
Sounds correct, yes.
Okay.
I would have had to gotten the drugs from 6
Okay.
to give to him anyways, so I just told him to skip me as the middleman that particular time.
So who's the middleman, you or 6?
I was.
Okay. Which is why all those drugs in your room didn't belong to you, right?
Correct.
Okay.
There was an extra gentleman that had been staying there for a while that didn't actually live there, didn't have his own space. So since I wasn't using the space, he was pretty much using my room.
Wasn't this a 3-bedroom house?
Yes.
Okay. At some point, you've got to become acquainted with the truth. You ain't anywhere near the truth now. And so, my guess is when you're done with your sentence, you'd be right back doing the same thing again.
I don't believe so, sir.
Yeah, I think so. But that remains to be seen. That's up to you. Anything else you want to tell me?
No.
Mr. Geigrich?
Thank you, Your Honor. I just want the court to recall that this case originated with the Lakewood Police Department Narcotics Unit, which contacted Lake County Narcotics about an individual from Menor selling drugs in Lakewood. They then conducted 3 controlled buys and did a search warrant on the home. He's talking about he's selling grams of meth for $20. Each one of these buys was for $40. It was my understanding that the charges were to be reduced to take him out of mandatory prison with an agreed sentence of 2 years, which the F2 would have done. At this point, it was my understanding that we had an agreed sentence of 2 years. At this point, the defendant is indicating he does not agree to that. So I'd ask you for a 3-year sentence. Thank you.
Ms. Tomaszek, do you want to address that?
Yes, thank you, Your Honor. I did have multiple conversations with Mr. Ruth prior to his plea and in the pendency of the pre-sentence report. I did reiterate to him on multiple different occasions that part of the plea agreement was the agreed 2 years. It was my understanding that Mr. Ruth did have an understanding of that. I do understand that Mr. Ruth does believe he does need treatment. I know he's gotten treatment in the past, but I know we've had multiple conversations regarding the plea agreement, Your Honor. Thank you.
Okay, I've reviewed the pre-sentence report and the drug and alcohol evaluation. And I have considered what Mr. Ruth has said, unbelievable as it may be, what counsel has said, what their agreement that was put on the record at the time of the pretrial, and the acknowledgement of that agreement by both counsel today. I've considered all the provisions of 29, 29, 11, 12, and 13. And I don't know why you come in here and spew the nonsense that you do and expect any consideration for that. You were given a very generous offer to get out of the substantial mandatory time of an F2. You have indicated to me today and in the pre-sentence report that they weren't your drugs, which is a lie. You have done your best to skirt the truth with Miss Warren and in this courtroom today. So I'm not going to go along with the agreed sentence. I'm going to sentence you to 30 months in prison with credit for 36 days that you've served, and the cost will be assessed. When you get out, you may be on post-release control for up to 2 years with the parole authority. If you are placed on post-release control and you violate any conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If the violation of post-release control is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which would be the greater of 12 months or the time left under post-release control. Anything else, Mr. Geigwitz? The remaining charges are dismissed. Anything else, Mr. Geigwitz?
The forfeiture of.
Forfeiture of the items. Ms. Tomaszek.
Nothing further, Your Honor. Thank you.
All rise.
Okie dokie, friends. TCF Live on this lovely, lovely Wednesday. It is good to have you all here. Let's change things up a bit. Let's go down to Louisiana. Check in on the parole board.
You're still on, you're on mute. I don't know if you know how to undo the, turn the sound on.
Good morning.
Oh, there you are. Good. Can you sit back a little bit, sir, so we can see you good? Yeah, that's much better. We can hear you fine. You don't have to get close to the microphone.
There was somebody else that said that he's still on mute.
No, you're on mute again. Oh, that was someone else that was speaking to us. Okay, I apologize. So Mr. Johnson, you may have to get up and ask the staff to help you with that.
She was rolling.
While they figure that out, quick reminder, In the Blind with Mike and Dan tonight, 7 p.m. Eastern, 4 p.m. Pacific. Barbara, if you drop a link, that'd be super duper. Thank you.
Phone's on mute. All right, we got it, I think. Yes. Thank you. Mr. Johnson, would you introduce yourself? Tell us your name and DOC number, please.
Roland Johnson, 369977.
All right, I still need you to sit back a little bit so we can see you. You were cut off about right here. That's better. Thank you. You have counsel today. Ms. Pierce, would you introduce yourself for the record, please? I mean, Ms. Perrette, I apologize. You're still on mute. Are you connected to the audio? No, still can't hear you. Oh, now I lost her altogether. Yeah, I still can't hear you.
Our volumes are not aware.
Is your volume all the way up? No. Can you hear us okay? Yeah, still can't hear you.
Well, as amusing as this is, friends, we are a couple minutes in the Wayback Machine, so let me bump
Check the
past this.
audio.
I think it was just an issue with my laptop.
There we go.
So would you introduce yourself for the record, please?
Good morning, everybody. My name is Grace Perrette. I work with the Orleans Public Defenders as a staff attorney, and I represent Mr. Roland Johnson. I have represented him since his arrest back in December, and it has been a pleasure to work with him.
Great, thank you. We also have from the Public Defender's Office, Mr. Terry Pierce, client advocate, and Mr. Derek Johnson, Roland's brother, who will be speaking, and we'll call on him in just a few moments to do so. So your case this morning, Mr. Johnson, has been assigned to Mr. Tillis, so I'm going to turn it over to him.
Okay.
Good morning, Mr. Johnson. I'm going to read some rule violations and you can answer guilty, not guilty, or with a statement. Rule number 4, you engaged in criminal activity as evident by your arrest on 12/14/2025 by the New Orleans Police Department for the charges of simple crime of damage to property and simple battery. How do you plead?
Not guilty.
Rule number 10, you failed to make payments toward your good time supervision since 11/10/2023 and an arrear of $1,804. How do you plead?
Guilty with a statement, sir.
Okay. Need to go and hear these other people now. All right, we're gonna hear from the Public Defender's Office. Mr. Pierce, Terry.
Good morning. Good morning. Thank you all for allowing me to speak for on Mr. Johnson's behalf. We have a plan for Mr. Johnson that will require him to enter a program and the New Beginnings program where he can understand what thoughts of, violation and aggressive moves and, just to help him to control his emotions at times. Mr. Johnson went through a period where he was working and he lost his job. And we all know how the economy is getting. Prices are ballooning. And he was paying his fees at one point while he was working. And when he lost his job, he got a little edgy with his nephew-in-law, and things got a little edgy. But Mr. Johnson been out for over 4 years almost, and he's been exceptional. And we have a plan of entering him into the New Beginnings program that's related right here, that's connected to this building on the 3rd floor. And I've already spoken with the people down there, and I have an application for him to complete right here. And I will help Mr. Johnson hands-on while he's coming into this building to make sure that he's complying and see to it that he become a productive citizen as he should be. Mr. Johnson is an elderly. He's no longer, really been out here doing extensive, things that was harming anyone, particularly he's been doing well. Thank you.
Thank you, Mr. Pierce. We have someone, his brother, Derek Johnson, to speak on his behalf. Mr. Johnson?
Yes. Hello, can y'all hear me?
We can hear you.
Okay, I want to say that I'm the second oldest of 11 children. Roland is the third. He's my little brother. We've been through a lot. We lost our mama, grandmother, and a couple of our siblings, to natural causes. So I want to say that I don't know how it affect him, but I know it personally affect me. I can't speak for everybody else, but I can assume that it kind of messed with him the same way. But as far as him having a chance to come home, I want to say that he do have somewhere to come to. It's a good community. No violence. one of my other brother's houses. He works for a living. I work for a living. There's no drugs, no alcohols, no weapons. It's close by a bus. So if he needed transportation, we do have a job waiting on him. When he get out, we all love him. We all my brothers and sisters, we love him. We want to see him home. And for myself, like I think he good with my kids because his parole officer give him a chance to come out here and spend some time with us for like a whole month. And my children don't like to exercise. He was able to get them out the house to exercise, something I couldn't even do. So he's good with kids. He's good with my children. And I just want to say we do have a plan for to help him if y'all release him back into society. I even got him a brand new phone. We have Wi-Fi. So because I know phones is like computers these days. And if he have a phone, he have access to look for even better jobs, but we already have a job lined up for him.
Okay, thank you so much. Ms. Barrett?
Good morning, y'all.
Good morning.
Yeah, Mr. Johnson, you should, if you're able to mute. There we go. All right. So I think the best part about working with Mr. Johnson, besides his personality, is the support that I've seen rally around him since he got arrested back in December. Mr. Johnson, as his brother mentioned, has a super extensive family and across both Louisiana and Texas. And unfortunately, we were not able to include a letter from Ronald Johnson, who is Mr. Johnson's brother that he'd be living with here in New Orleans upon release. But we're happy to provide that address on the end. At the end, I've spoken to Mr. Ronald about where he's going to be living and this job they have lined up for him. It's a mobile detailing service. So he does have immediate support ready for him immediately upon release. I just wanted to confirm, y'all have received the packet that I submitted on behalf of Mr. Johnson? Okay, perfect. I don't want to rehash every single point of what I had submitted, but I think the bottom line on Mr. Johnson is like Mr. Pierce said, he has spent over 3 years up until the point of his arrest, almost 4 years successfully on parole. I have spoken to Agent Goins, who was working with Mr. Johnson at the time, and he really didn't have issues beyond the fines, and he knew that Mr. Johnson was looking for new employment. He was actually supposed to start a new job right before he got arrested. With regard to the new charges, the 2 misdemeanor charges were both refused by the district attorney's office in January. He has now spent over 5 months on those charges while we've been kind of navigating the parole process. And I understand that the allegations, I understand why they would be cause for concern for the board. But I think that it's important to emphasize a couple of things. The nephew that they were living with, who is the named complaining witness, is an adult. My understanding from conversations with Mr. Johnson, as well as Ms. Brumfield, his partner, is that there was a lot of concern about the fact that he wasn't respecting the fact that Mr. Johnson was on papers. And this argument started out over Mr. Johnson, over the nephew, smoking weed in the house and having drugs in the house. And this is Mr. Johnson was trying to remove himself from that situation. And unfortunately, he did so too late. But what I would point out to the board is that Mr. Johnson, immediately after leaving, he left the situation to cool off, and then he called his parole officer. And I've confirmed this with his parole officer. Neither of them knew that a warrant went out regarding these charges, but Mr. Johnson called Agent Goins. They got him into a halfway house. They got him out of that living situation. And he's been separate from those folks, or at least from the nephew, ever since. Mr. Johnson understands he should have left that situation earlier if it was going to jeopardize his parole. And I think he will speak more to taking accountability for that. But he has a good place to land, and he has been a productive person on parole. With regard to the fees, he understands he should have been working more with Agent Goins to get those fees paid. He did pay fees for about the first year while he was consistently employed at Rouse's, and then he was laid off due to budgetary issues, is my understanding. And so he understands that's a priority. He's going to be meeting with Mr. Pierce. Mr. Pierce is going to be keeping him accountable to keep in that job and making sure that everything is paid as much as it can be on time, that he is reaching out to his agent and to his family if he's struggling. We would just ask that in lieu of revocation, y'all consider doing these check-ins with Mr. Pierce, making sure that he's providing his proof as much as he can. And eventually, Mr. Johnson's goal is to transfer his parole to Texas if possible. I have spoken to Agent Goins about this. He is supportive of that plan. He's been supportive of that ever since Mr. Johnson went and visited Derek and the rest of the family out in Texas. So I think he has both a short-term plan and a long-term plan to be successful on parole. And we would ask that you do not revoke him today. Thank you.
Thank you so much. Any of my colleagues have any questions?
I've got one, and it came up with the fact that the attorney mentioned that you've not been around the person that you bit in the face, the nephew. But what about the other complainant? Have y'all been together, your partner?
Yes, ma'am. Me and my partner been together since I've been home, and we've been doing pretty good. We built the place that we live together, and we've been there ever since. We've been doing pretty good.
Let me read something. So it was that it said when asked by the officer, Ms. Brumfield stated that she and Mr. Johnson have been dating 2.5 years and have lived together for, it says how many months, they have no children, but that y'all do have a history of domestic violence. So even though sometimes the police is not called inside those walls, there can be hitting, pushing, and shoving that's going on that never get reported to the police. And then it escalates to what we had here. So I'm concerned about that, and I do like the idea of the Texas relocation. I'm concerned that, all of this happened, and you said that y'all were back together again. You said that y'all be staying in the same home. And she said to the police that y'all have a history of domestic violence.
Well, I removed myself from the situation, man. Tanisha, we're not together anymore, but there's no bad blood.
Well, that's good. No bad blood, but yeah, even better if you were in another state, then you're not going to get back together or anything, because sometimes two people just don't mesh right, and then it leads to tragedy. So I did want to address that.
Yes, ma'am.
Do you have any contact with her?
Yes, ma'am.
And I would just note for the board that there was never a protective order put in place with Ms. Brumfield. The protective order was specifically against the nephew. And Ms. Brumfield did write a letter of support for the board. It's in the packet. I just would point the board to that, just so everyone. She had considered speaking, but chose not to today. I spoke to her 2 days ago. She is in full support of him coming home to his family and understands that her home is just not the most supportive place for him. And they both understand, I think, the necessity of moving on.
I'm ready to vote.
All right, Mr. Tiller.
My vote today is going to be do not revoke, with conditions that he get with Mr. Pierce on a short-term basis, and hoping that his long-term basis will be with his family in Texas.
Ms. Stapleton?
I agree with Mr. Tillis. Same thing, that your long-term, that you do relocate to Texas. So there's there's no further problems in this situation.
Okay, I do agree. I think the plan worked out by the Public Defender's Office and the New Beginnings Family Services Program will be beneficial. So, and with his brother, right? Is that
Ronald.
That's
Yes,
where,
ma'am.
Ron Johnson. Okay, so that you, upon release, he's to, they have to approve it, but I'm sure they will. The approved residence with his brother, complete the New Beginnings program while he's working on the long-term plan to Texas. Do you understand, Roland? what
Yes,
we
ma'am.
trying to-
Yes, ma'am, I do.
Okay. Good luck to you, sir. You're not being revoked, but you got some work to do.
Yes, ma'am.
Thank you.
Thank you, ma'am.
Approved?
Well, go figure, not a denied. Okie dokie. Let's go back up to Michigan. Little time with the new favorite of so many on this channel, Judge Aquilina.
This, all right, this is docket 21898FH, People of the State of Michigan versus, is it Letitia?
Yes.
Monica-Marie Wells. Counsel, your appearances for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of People of the State of Michigan.
Ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. Ma'am, you were on bond conditions, and this is an old file. And you failed to appear a number of times since 2021. And now you were picked up on a bench warrant that I've had outstanding since December 20th, 2021. And it reads, defendant tested positive on November 22nd, 2021 for methamphetamine. Defendant failed to drug and alcohol test on November 29th, 2021, December 11th, 2021, December 13th, 2021. I think this should be amended to say that she also failed to report for pretrial services monitoring since 2021. Would that be also accurate?
Yes, sir.
So I'm going to also add that. Otherwise, they might try to violate you again. So defendant failed to appear for pretrial services since or about I was going to put since on or about December 16th.
Did you say December 16th?
16th, 2021. And anytime thereafter. And you are entitled to an attorney. Would you like me to appoint you one?
Yes.
All right. And we're going to reset this, okay? Is that a yes?
Yes.
Okay. So we'll go through all your rights and everything then. But you do have a right to an attorney, you have a right to a hearing. This is by preponderance of the evidence. You have a right to cross-examine any witnesses and evidence brought against you. You have the right to choose to provide a defense, but you don't have to. If you want any witnesses present, the court would order those witnesses to be present. If you remain silent, your silence cannot be used against you. If you want to testify, you certainly can. The people would be able to cross-examine any witnesses, evidence, and yourself if you testified. In a violation of this kind, it's not beyond a reasonable doubt, as it is with your charge of count 1, controlled substance possession of methamphetamine. That is a 10-year felony and or $15,000, and there could be license sanctions. Now, that you are presumed innocent until proven guilty beyond a reasonable doubt, but on a violation of bond conditions, it's by preponderance of the evidence, which means more likely than not. Do you understand all of that?
Yes, ma'am.
All right, so I'm gonna remand you to jail until we have this hearing. I'll give you a date in a moment. We're going to appoint you a public defender to represent you. Ma'am, it looks like you have a long history with meth. I don't know what other drugs you're using, but in regard to the jail, do you need to be treated? Are you gonna be going through withdrawals or anything? I want to make sure that jail is put on alert and it has medical available for you.
They have me at Suboxone.
Okay, so they're monitoring that?
Yeah.
Are you doing okay?
Yeah.
Being on that medication, do you understand everything I've said?
Mm-hmm.
Is that a yes?
Yes, ma'am.
Okay, so I'm gonna keep you there for your own safety and continue treatment, or you're gonna get your lawyer, and you're gonna be back in front of me. Is that okay?
Yes, ma'am.
All right, do we have time next Wednesday? I'm just gonna put for Wednesday at 11:45. And that's June what?
That's June 10th, Your Honor.
June 10th. All right. And then if the lawyer wants to change it, or we need to change it to another day, we'll let you know, but June 10th at 11:45. Okay?
Okay, thank you, ma'am.
And we'll put a note that you should continue with the Suboxone and having medical see you. All right, thank you.
We're gonna handle Percy George next. Percy George.
Oh, okay, this is docket.
Oh, wait, I'm not ready.
Okay.
All right, we'll probably, well, no, defendant's here. We'll stay.
Yes. This is docket 14-554 FH, People of the State of Michigan versus Percy George. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide me the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand on. You represent yourself?
Yes, ma'am.
And that's perfectly fine. An application to set aside the following conviction was filed on April 20th, 2026. That's controlled substance delivery manufacturer of controlled substance. There's just that one count. On behalf of the people, any objection? It looks like the requisite paper from the Attorney General and the state police has been provided.
That is correct, Your Honor. We have received that letter. That letter does state that according to his criminal history, he would be eligible for the conviction to be set aside. So we just ask that the court determines whether his post-conviction circumstances warrant a setting aside and that it's consistent with the public welfare. Thank you.
Sir, what have you done since then? It's been what, 12 years?
Yes, ma'am.
All right, so what have you done since then?
I acquired my LLC. I've been working on myself and trying to build my own business. I own 34 Duncan live streams and vlogs.
Wow.
Yes, ma'am. Yeah, that's about it.
So it sounds like a fun job.
Yes, ma'am.
All right, so you stayed out of trouble, very impressive, and certainly you deserve this, sir. All right. The Michigan State Police has reported the required information from its records to the court. The applicant has not been convicted of more than 3 felonies. The applicant has had no convictions for assault or crime set aside pursuant to the statute during their lifetime, and there are no criminal charges pending against the applicant. The applicant has not been convicted of any criminal offense during the applicable time period required under the statute. The applicant is requesting that a felony punishable by more than 10 years imprisonment be set aside and has not had any previously set aside convictions for the same offense pursuant to the statute. The applicant has not previously applied to have and had a first violation. I don't know why that applies. Frank, can you approach the spot for record a moment? Which one has that checked? Okay. All right, let's go back on the record. We're gonna just make the correction on what was filled out. Time period required by the statute for the conviction listed in item 1 has passed, and an opportunity has been given to the Attorney General, State Police, and prosecuting official to contest the application. No one has. Circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of the application more than warrant and justify setting aside the conviction, and it is consistent with justice and public welfare. Therefore, the application is granted as to the conviction listed in item 1. And the Michigan State Police shall maintain a non-public record of the order setting aside conviction and of the arrest, fingerprints, conviction, and sentence of the applicant in the case to which this order applies. If the court or arresting agency maintains a record of the arrest, biometric data, conviction, or sentence, that record shall be non-public and not used for any purpose unless authorized by law.
I got it right here.
All right, sir, this has been read, dated, signed, and corrected in open court. So, I see a lot of drug charges, and ultimately, many people have multiple drug charges, and then it leads to gun charges and a whole lot of other things. The fact that you took it seriously, no other charges, and you created a business for yourself, sounds like multiple businesses. It really speaks volumes as to your character. Everybody can make a mistake. It is the lessons that we learn. Those are all teachable moments. And sir, you certainly have learned your lesson, and I commend you for coming to court and publicly telling us that you've done that and doing such a great job, because you are a leader then in our community for the actions that you've taken, and you are an example to really all minors, especially. You're not home.
33.
Yeah, so you were pretty young when that happened, right? And when you're young, you can make a lot of mistakes, but really it's what you do with them. So you are just a great example to young people about you can get over it and climb the mountain and reach the top. So I don't know that you're at the top yet. I'm going to expect to see even more greatness.
Yes, ma'am.
But at this time, I'm going to ask you to come forward.
Come forward.
Yeah, I know I'm scary, but come on. Congratulations.
Thank you.
Here you go. Good luck to you.
Thank you.
Sir, here's an extra copy, just so you have too.
That is all for the record. Now you go out and celebrate with your loved ones, okay? That's my final order.
Yes, ma'am.
Thank you.
Well, that's a nice moment that we don't often get to see. Somebody successfully turning their life around. I like it. Unfortunately, we're now going to go to Lake County, Ohio. We're going to check back in with Judge O'Donnell, and I highly doubt that we're going to see the same.
This is 24-1340, Tyler Golphin, violation of community control. First violation, defendant forged AA meetings when he reported April 30th. You understand that charge?
Yes, Your Honor.
Second, failed to attend 4 AA meetings as ordered. You understand that charge?
Yes.
Ms. Tomasic?
Yes, thank you, Your Honor. I spoke with Mr. Golphin. He indicated today he would like to waive this final hearing and admit to the violations, and we're prepared to proceed to sentencing. Thank you.
Is that what you want to do?
Yes.
What's your plea to those charges?
It's good.
Accept your guilty plea and find you guilty, Ms. Tomasic?
Yes, thank you, Your Honor. Mr. Golfin would like to ask for another opportunity to continue his community control sanctions. Your Honor, he did recently obtain a job. It is at On Track. It's near the airport. He is supposed to have orientation coming up. He did speak with his job. They are holding the job for him. Your Honor, he indicated it has been difficult to get to 4 AA meetings a week. He did recently crash his car. It is very expensive to get fixed. One of his top priorities is to get a new vehicle to be able to do the transportation. So, Your Honor, we'd just like to ask the court today for another opportunity for Mr. Golfin to continue community control sanctions. Thank you.
What do you want to tell me?
Nah, I just made a bad decision. I was trying to be slick and it wasn't right. I was doing my means, but it just kind of got hard. And then I back and forth trying to get into school and with my new job, looking for a job and taking care of my 3 kids. And I just couldn't make it to all the meetings. So I just did like kind of a backyard meeting, me and a few friends, and I just had one of them.
There's no such thing as a backyard meeting.
Exactly. So it was just like,
And you know that.
It was
Otherwise,
wrong
you wouldn't have submitted. Never mind. Go ahead.
Yeah, so it was wrong on my end. I take accountability for having that on my AA papers.
Okay. This is your second violation, right?
Yes.
First violation was using meth and using cocaine and using ecstasy, right?
Yes.
Okay. And when you came in for that violation on April 22, I continue your probation with the same conditions, meaning I guess there was a good reason for the 4 AAs a week when I initially did that a year ago, right?
Yes.
Okay, so you were to continue with everything I told you to do the last time you were there. And you didn't. Because you didn't want to. So if you're not, if you've, listen, first of all, your offense was terrible, the original offense. What was the original offense? What did you do?
Mishandling a firearm in a motor vehicle.
What?
Mishandling a firearm in a motor vehicle.
Mishandling meaning shooting it, right?
Or carrying it the wrong way. But in my case, shooting it.
Didn't you shoot it?
Yes.
Okay, it wasn't just carrying it the wrong way, you shot it. And you said you were chasing who? Your girlfriend?
No.
Who?
Her and her brothers.
Her and her brothers. Why were you chasing her and her brothers?
Because I was intoxicated and I thought they was coming to my house to do something to me.
Okay. And when you caught up to him, she heard you say, give me a reason why I shouldn't blow this bitch up, right?
Yes.
And you shot the firearm.
Yes.
And yet I gave you probation.
Yes, Your Honor.
Was and I guess I was wrong. Because I sentenced you on May 16th. And you're using meth, ecstasy, and cocaine 7 months later. And I still kept you on, giving you every opportunity to straighten your ass out. And you haven't done it. Because you get out of here after 122 days in jail. What was the date of the April 30th? Was that when it was, Jamie?
Yes, Your Honor.
Okay, 8 days later, you're turning in phony AA meetings to your PO. So explain to me again why I would keep you on probation?
So I can get better.
Well,
had
you done the things that you were ordered to do in May, you'd be well on your way to getting better. But you don't do it, because you don't want to do it. You haven't done a thing to make yourself better. What else you want to say?
Nothing.
Ms. Thomas, anything else from you?
Nothing further, Your Honor. Thank you.
All right, you are not amenable to community control. You've demonstrated that twice after the nature of that offense to begin with. So I'm going to terminate your community control. Your sentence is 16 months in prison with credit for 330 days, and the costs are assessed. When you get out, you might be on post-release control for 2 years under the parole authority. If you are on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which is the greater of 12 months or the time left under post-release control. Anything further, Ms. Thomas?
Nothing further, Your Honor. Thank you.
So I'm off of probation. I go to prison. Good.
Alrighty, friends, let's head back to Judge Aquilina, new contestant there.
Docket 261957FH and 23501FH. People of the State of Michigan versus Carl Mendenhall. Counsel, your appearances for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the State of Michigan.
And Luke Goodrich from the Public Defender's Office here to represent Mr. Mendenhall, who's standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No.
Any sign of fever, COVID, or other illness?
No, ma'am.
Is there medication you're supposed to be on that you're not on? Okay, and you had enough time to talk with your attorney about all these matters?
Yeah.
All right, and I understand that this is a pretrial conference as well as a bond hearing. Have we had a pretrial conference?
Well, Your Honor, the status of the pretrial conference, it's kind of a continuing matter in that the plea offer in the case involves a third file. Thanks to Mr. Buxton's efforts, that case has been filed now in the 54A District Court. He is scheduled to be arraigned on that tomorrow.
Okay.
So it's probably not going to be up to this court for about 5-6 weeks.
Okay.
Guessing on the
What are
time
the
frame
new
there.
charges?
It's a fleeing and eluding fourth.
Okay, so, all right, that's it?
Yes,
Okay,
so that's what we wanted to address bond. The court previously, Mr. Mendenhall didn't show up for court for a year or two. So the court sentenced him to 90 days contempt with I think 2 months ago. He now has 64 days credit on that. I would ask the court to consider suspending the rest of that sentence at this time and granting him, which would be on file 23-501FH, and granting him a PR bond on file 26-1957FH. So, and then the bond would essentially be reinstated on the 501 case to give him an opportunity. And related to that fleeing and eluding case, Mr. Mendenhall obviously suffered severe injuries, including to his neck. The last time we were in court, the court wanted him to be able to get a soft neck brace in the jail. However, the jail will not do that unless he's willing to go into solitary confinement, which he does not want to do. He needs more medical attention as far as being evaluated, and he likely is going to need additional surgeries in the future. So we would ask if he's willing to do tether, if the court would like to have him on tether. I understand he obviously didn't have a good history of showing up to court after missing all that time. So but he's willing to do tether, but he needs to be able to get out and take care of his medical situation. He'll likely get some type of 10% bond or something like that on the fleeing and eluding, so we'd have to post that as well tomorrow, hopefully. So he has a place he can stay with either his mother or his older brother locally. So we would ask the court to, again, like I said, suspend the remainder of that 90-day sentence, reinstate his bond on the 501 case, and then convert his 1957 case to a PR bond at this time, Your Honor.
So does he have a verifiable address, or are we just kind of cherry picking addresses?
He can stay with his mother at the 3708 Lockmore Drive.
Counsel, response?
Yes, Your Honor. The concern that the people have, Your Honor, and it was briefly mentioned by defense, but the defendant has been FTA for essentially 2 years at this point, Your Honor. In both matters, Your Honor, he actually fled prior to the case being brought up back in January of 2024 on the 26-1957 case. He was then picked back up recently, and obviously he fled on the other case as well. So a little over 2 years in regards to the one that was in district court at the time he was re-picked up. Additionally, Your Honor, with this new case being a fleeing and eluding from the time period in which he was still FTA from the court, the people are concerned that the defendant has a pattern of running from police and running from these criminal charges. So this case should be up shortly. Like defense said, I contacted pretrial services in district court, and they will be doing an arraignment for him tomorrow. That case should be up shortly, and then we can resolve that matter. And at that point in time, I believe, I think the matter can be resolved. But the people's concern is that if Mr. Mendenhall is let out, he is a flight risk.
So there's a preliminary exam tomorrow?
There's an arraignment tomorrow on the new charges. So the preliminary examination won't be for another 2 weeks.
Yeah, if not 3.
If not 3, correct.
Counsel?
No, Your Honor, just the timeline. I was just spitballing the math. If he gets arraigned tomorrow on June 4th, I think his preliminary exam will likely be on the 25th, which would be the 21 days. Then after that, it'd probably be July 8th or July 15th when he has a circuit court arraignment to get the case to your court.
Sir, anything else you want me to know? So, sir, if I release you on GPS teller, you need to stay at a place with a plug. I assume your mother's place has a plug.
Yes.
And you're welcome in her home.
Yes.
So, if you're stopped by law enforcement, you have to stop, not run.
Yes, ma'am.
You can't be in the presence of any victim or witness. And you need to show up to court, whether it's district court or here. So otherwise, I just have to keep you in jail. The one who's kept you there is you. You haven't shown up, you're not following any of these rules. You don't get to make up the rules. I don't get to make up the rules. There's laws, we all have to abide by them. So we can live in a peaceful community. So quit being a disruptor and follow the laws. And that means following what I'm going to tell you now. Because if you don't, it's called jail or prison. And we get you medical care once we sentence you. If that's what you want. Thing is, sir, people always blame others for putting them behind bars. You put yourself behind bars, you didn't show up. And now we don't have 2 files, we have 3 files. And if we have any more, because I have every right under the rules we operate because of public safety to not let you out. So again, you have the keys to the jail. So you have some decisions to make. I can't make those for you, and your attorney doesn't have any magic tricks. He does a really good job. I've known him for many, many years. But the more files you accumulate, the less he has to say and the less I believe. Does that make sense to you?
It makes very good sense.
Okay. So, sir, I'm going to give you a PR bond and all your files in the amount of $25,000. I am going to forgive the balance of jail on the contempt and release you upon 2 things. Verification of your address, and that's your mother's address at the 3708 Lockmore Drive, and your arraignment on the new charges, which is June 4th. Now, I don't know what they're gonna do. Maybe they'll release you. Hopefully they do. If not, I guess there'll be another motion filed in front of me. You will be released with a jail GPS teller. We do have it. I'm gonna make a note. You probably need the indigency grant. You've been working for a while. If you don't need it, then do apply for it. You will show all prescriptions to pretrial services from licensed medical physicians, and you will take any psychotropic medication, if any, as prescribed. You can use over-the-counter medications as labeled on the bottle. You can use less but not more. You'll follow all doctors' recommendations. You will PBT and/or drug test as requested by pretrial services, law enforcement, any court officer, or your mother. Since you'll be living with her, you will not only have in your possession or under your control a weapon, gun, ammunition, imitation of a weapon. You'll not be in the presence of third parties who have any of those items. You will not be in the presence of any known felons or any known gang members. You'll not wear any gang colors, insignia, or gang tattoos. Is there anything I have missed?
No, Your Honor.
No, Your Honor.
Any questions, sir?
No, ma'am.
Your best behavior, please.
Yes, ma'am.
Okay.
Thank you, Your Honor.
Thank you.
We're gonna give you copies of this. That's all for this record, thank you.
Okay, friends, a few more minutes left. We're going to go back to Judge O'Donnell, new contestant there, and this will probably finish out our day.
Thank you, Your Honor. The state is recommending that the bond as set by the Mentor Municipal Court be continued at $10,000 cash or surety 10% with the following conditions: no contact with the victims, and Popeyes may not reside or travel outside of Lake and Cuyahoga County or the state of Ohio without the express authority of the court.
At 10,000 cash or surety or 10%, no contact with the victim, no travel outside of Lake or Cuyahoga County.
Thank you, Your Honor.
All right, Ms. Cutts.
Thank you, Your Honor. We're here today in State of Ohio versus Jacob M. Cochran, case number 26CR000600. Defendant is present in open court today with his counsel, William Watson. Your Honor, we're here today for an in-court arraignment. The defendant was indicted on a 4-count indictment on June 1st of 2026. He previously had his bond revoked out of the municipal court, so bond is revoked at this time. And that is the state's understanding today.
All right. Mr. Watson.
Thank you, Your Honor. May I please the court? My client is in receipt of his indictment. Will waive any 24-hour service, any service defects, any reading of the indictment. Would like to enter a plea of not guilty to all the charges and would like to respectfully be heard on bond at the appropriate time.
All right. Not guilty plea will be entered as to bond. Mr. Watson.
Thank you, Your Honor. May I please the court? Mr. Cochran was initially granted a bond out of Willoughby Municipal Court, which included a scram bracelet that was installed. He was released from the jail. There was apparently a mix-up with notifying Mr. Cochran with regards to his court date. He did miss that court date. Several months went by when the scram people just showed up and removed it. He was unaware that there was a warrant. He thought the case was dismissed. He has maintained his innocence in this matter. He hasn't been on the run. He's been at home where he's supposed to be the entire time. I'm going to respectfully ask the court to consider, I know we can't reinstate his bond, it's already been forfeited, but if the court would consider a monetary bond, a reasonable monetary bond in this case, and or an OR bond with whatever other restrictions the court would deem necessary to ensure his appearance. I'm sure Mr. Cochran will appear. He's eager to resolve this matter. Thank you, Your Honor.
Thank you, Ms. Cutts.
Thank you, Your Honor. The defendant was originally arrested in this case on October 1st of 2024. He was arraigned on October 2nd of 2024 in the Willoughby Municipal Court. He was given a bond of $7,500 cash surety or 10% with scram, no driving, and no use of drug or alcohol. He bonded out on October 8th of 2024. His preliminary hearing was set for October 10th of 2024, which he failed to appear. A warrant issued on October 16th of 24, and bond was officially forfeited on October 29th of 2024. He was then arrested on his warrant April 23rd of 26. So that was 18 months that the warrant was out for. It would be his requirement to be in contact with his counsel during that time frame. I cannot say what he is indicating about notifications or anything of that nature, but if he thought the case was over and it was months later for Scram to come, he should be in contact with his counsel to know. He could check the docket, but that warrant was out for 18 months and nobody located him in that time frame. This case was originally bound over as 2 felonies and multiple misdemeanors. He was indicted on 3 felonies and a misdemeanor, as well as he does have a prior criminal history of criminal convictions that go back to 2009. He also, during that time frame, has contempt of courts, other OVIs, obviously since this is a felony OVI, as well as probation violations in those cases. Based on all of that, we did feel the bond remaining revoked was appropriate. If this court is inclined to give him a bond, we do feel it should be a higher bond with a GPS as well, so we can be sure of where he is.
All right, the bond will remain revoked.
I'll see you in jail.
Hold on 1 second. Sir, Cochran, Mercer. Hold on, sir. Yeah, go ahead and go back and just sit there. All right, that's just
All right, Ms. Himmeline?
Thank you, Your Honor. We are hearing case 26 CR 593, State of Ohio versus Isaiah McCoy. Present in court is a defendant who's accompanied by his attorney, Mr. William Watson. We are present today for an in-court arraignment on a 3-count indictment that was filed May 29th, 2026. And we are also present today for a change of plea. It is the state's understanding that the defendant is prepared to plead guilty to count 1, having weapons while under disability, a felony of the 3rd degree, with a voluntary forfeiture of all items seized. The remaining counts of the indictment would be dismissed at the time of sentencing.
Thank you. Mr. Watson?
Thank you, Your Honor. May it please the court, that is correct. That's my understanding of this morning's hearing. With regards to the arraignment, my client is in receipt of his indictment. We'll waive any service defects, any 24-hour notice, any reading of the indictment. Would like to enter a plea of not guilty to all the charges. And then, Your Honor, it is correct that after that not guilty plea is entered, my client wishes to proceed by entering a change of plea with a previously agreed upon plea deal with the state. My client understands that by entering a change of plea, he'll be waiving certain constitutional rights and no threats or promises have been made in order for him to do so, Your Honor.
All right, not guilty plea will be entered. And as to the, you said it was count 1?
Yes, Your Honor. It would be count 1, having weapons while under disability, a felony of the 3rd degree. The state would dismiss counts 2 and 3 at the time of sentencing, and there is no agreement with regard to sentencing.
All right, thank you. Mr. McCoy, how old are you?
I'm 21.
How far did you go through school?
9th grade.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
No.
Did you get a copy of this indictment?
Yes.
It's my understanding you're going to plead guilty to count 1, having weapons while under disability, of felony 3, and forfeit and the forfeiture specification, and then counts 2 and 3 would be dismissed at sentencing. Is that your understanding?
Yes.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Mr. Watson some more, let me know and I'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to be given a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to copy those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to count one?
Yes.
You understand by pleading guilty, you're fully admitting your guilt to the charge.
Yes.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time. I could sentence you to prison, to jail, or to community control.
Yes.
Having weapons while under disability in count one is a felony of the third degree. It carries a maximum prison sentence of 36 months and a maximum fine of $10,000. Do you understand that?
Yes.
If you plead guilty to the forfeiture specification in count one, you're voluntarily giving up any right you would have to the items listed. Do you understand that?
Yeah.
Are you presently on post-release control to the parole authority?
No.
Do you understand your felony conviction prevents you from owning or possessing a firearm?
Yes.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and violate any conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes.
If that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 36 months. Do you understand that?
Yes.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk with Mr. Watson before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions at this point?
No.
Ms. Himmeline, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this matter proceeded to trial, the state would establish beyond a reasonable doubt that on March 12th, 2026, in the city of Willoughby Hills, Lake County, Ohio, the Willoughby Hills Police Department initiated a traffic stop on a vehicle traveling 102 miles per hour in a 65 mile per hour zone. The driver of that vehicle was identified as the defendant. The defendant's temporary driving permit was suspended at that time, and there was an odor of burnt and raw marijuana emanating from the vehicle. As a result, the police department searched the vehicle. They located a backpack inside the vehicle with the defendant's wallet, his state ID, and temporary permit, along with a loaded Canic TP9 SFX 9mm pistol, serial number 21BC 25555. The police obtained a search warrant for the defendant's DNA standard for comparison to the firearm. The firearm was sent to the Lake County Crime Lab for testing. It was determined to be an operable firearm, and the defendant's DNA was present on the firearm. The defendant does have a prior conviction for a felony offense of violence, and that is robbery out of Cuyahoga County Common Pleas Court, case number CR-24-691958-A, dated November 13th, 2024. Along with an accompanying SYO disposition in juvenile court, case number DL 241008888, dated January 13th, 2025. Thank you.
Thank you. Mr. Watson, anything to add to those facts?
No, Your Honor.
Mr. McCoy, did you hear what Ms. Himmeline said? The facts would show if the case went to a trial.
Yes.
Are those facts true?
Yes.
What is your plea to count 1, having weapons while under disability, a felony 3?
Guilty.
And what is your plea to the forfeiture specification?
Guilty.
Mr. Watson?
This is the same paperwork we went over, so there's no changes there. So, except you are a U.S. citizen, so you should just sign right there, but today's date. Today is 6/3/26.
Your Honor, I have the written plea of guilty and judgment entry that was signed by the defendant in open court. It was written by Anzalone.
Mr. McCoy, is this your signature on the written plea of guilty?
Yes, it is.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes, please.
I'll accept the written plea of guilty. Defendant was present. Mr. Watson advised of all of his rights in a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept the plea of guilty and find him guilty of count 1, having weapons while under disability, of felony 3. I'll refer this for a pre-sentence report. Sentencing will be July 9 at 8 a.m. Mr. Watson?
Your Honor, thank you. May it please the court, if we could be heard on bond. There was a bond initially set in this matter out of Willoughby Municipal Court. My client at the time was homeless, so he missed his first preliminary hearing date. I actually filed a motion with Willoughby Municipal Court explaining the circumstances. Another preliminary hearing date was set. Again, due to his housing issues, we had trouble getting a hold of him to inform him of that date, so we missed that date. Bond was revoked. My client, I was able to get a hold of him. He knew there was a warrant out for him. He didn't run and hide. He turned himself in voluntarily, Your Honor. He does have a place to stay now. I'm respectfully asking the court, that particular bond has been revoked. It's gone, but I'm respectfully asking the court to consider either giving him an OR bond or granting him some reasonable monetary bond between now and sentencing. Thank you, Your Honor.
Similar.
Thank you, Your Honor. The state would ask that the bond remain revoked in addition to his failure to appear twice in Willoughby Municipal Court. The defendant, despite being 21 years of age, has a significant criminal history. He has multiple juvenile adjudications for assault and having weapons under disability. He has an aggravated trespass conviction from 2024 in Cuyahoga County. He also has a robbery conviction, as was set forth during the change of plea, for which he received a prison sentence and then a juvenile disposition. He does also have pending in Cuyahoga County Common Pleas Court another case for having weapons while under disability, and that was indicted in 2025, and that case is still pending before the court. Thank you.
All right, the bond will remain revoked.
Okie dokie, friends, that does it for today. I hope you all enjoyed the show. I had fun bringing it to you, so thanks so much for giving me your time this morning. We'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. Go have yourselves a great day. Take care. God bless.